This is November the 5th, 2003. We're doing an oral history of Mr. Doug Noble, who is retired from the Attorney General's office and represented the Colorado River Board on behalf of the state of California. I may talk a little louder than I have to because you've got the microphone. So
Okay. Would you like me to look at you or the camera?
Either
All
one,
right,
really.
all right.
I mean, don't stare. I mean, that's the
Yeah,
bottom line.
yeah, yeah.
Feel free to animate. Doug, I wonder if you start the tape here with a little bit of personal background information. What part of the world are you from? Where did you go to school? How did you get tied up into the wonderful world of water? We were talking earlier, and you were in the Peace Corps, and maybe talk about that for just a minute or two, just so people have a sense of the person.
Well, I'm a native Californian. I was born in Santa Monica, California, 1943. Lived there until I was 8 when my mother remarried and we moved to the Valley where I went through school. I graduated from Van Nuys High School in 1960. Attended UCLA for a year and then transferred out to what was then Claremont Men's College and graduated there in 1964 with a major in political science. I went to Stanford Law School. I graduated in 1967. While I was at Stanford, my property law professor was Charles Myers, who, as I later found out, was one of the two main clerks to Special Master Simon Rifkin in the original Arizona-California trial. And I also had Charlie, who became a good personal friend, for water law and was always interested in that area, although I never dreamed that I would get so directly involved in what he had done. After law school, I went in the Peace Corps, partly out of altruism, partly to have alternative service to Vietnam. And I was in Guatemala for 2 years, where I worked with rural savings and loan credit cooperatives. And a pretty good program. It was one that was funded by AID. And it was a period of time that I think really significantly affected my life in terms of making me more open to new ideas and challenges. And certainly, I'd always been interested in traveling, but it certainly expanded that. And it got me away from home. And it was just a great experience.
What kind of work? You weren't doing legal work for them, I worry.
No, I was doing some accounting, working with their various education auditing committees. These were small credit unions in Indian towns where people had never had any experience really working together cooperatively, and where they had, in the past, before the credit unions came, when they needed money, were forced to borrow from the town user at totally exorbitant rates. And the credit unions provided them a vehicle not only to work together for the common good, but also to learn to save themselves and to have a cheaper source of credit when they needed it through the credit union. It was actually, I don't think the entrenched powers in Guatemala at that time, and Guatemala was fairly calm at that time, I don't think they realized what an essentially revolutionary thing a credit union was, because it did, in a sense, begin to motivate these Indians, Highlands Indians, who'd been totally separated from the economic and political mainstream of the country, to get involved, to realize they could do something about their lives. And I think eventually that was part of the element that led to the Civil War. We certainly weren't fomenting revolution, but I think in a way, in an indirect way, we helped that happen. Now, whether that was a net good in the long run is subject to debate, because the Civil War, which came to Guatemala about 10 to 15 years after we were there, resulted in a lot of people being killed, including my two best friends. And I don't know whether the net gain in the long run was worth it or not, as often happens. They were Guatemalans, yes, yeah. But I've kept a lot of contact with Guatemala. I've been back a number of times, and we had a very closely knit group of volunteers in our group, and we've had 6 or 7 reunions, all of which I've organized pretty much. And and some of my closest friends to this day are people that I knew in the Peace Corps. And in fact, I got into the Attorney General's office after the Peace Corps because there was a man in our group, well, a couple in our group, who left early. They terminated early. They didn't serve their full 2 years. But he came back and went to work in the California AG's office, and we had become good friends already, and he told me that he thought it would be a perfect place for me to work. So when I came back, in those days, getting hired was a little bit easier than today. There weren't too many hoops, and he basically kind of greased the wheels for me to be hired there, and I had interviews, but...
Had you passed the bar by then?
I had taken and passed the bar before I went in the Peace Corps. In fact, I was sworn in Guatemala City, and I had to pay the U.S. consul $5 to swear me in, which was a hell of a lot of money when you were making only $90 a month. But anyway, I wanted to be sworn in, so I had more time in my bar history. Anyway, this man, Jeff Miller, who is now a federal court judge in San Diego, really got me into the AG's office, and we've remained very good friends since. And so I started in the AG's office in September of 1970, about 6 months after getting out of the Peace Corps. Like everyone in those days, I started in criminal appeals. Everyone in those days came into criminal appeals. For one thing, they discovered, if they didn't know it before, whether or not you could write, which, because you were writing all the time, and of course, just because you went and graduated from law school didn't mean that you could write worth a damn. But that was kind of a test. And at that time, it was understood that after serving 2 or 3 years in criminal appeals, if you wanted, you had the option of moving into another section. And while I was there, I came to know Carl Barranque, who was head of the then Public Resources section. We became friends. I don't remember how. It was a small office in those days, and he was senior and I was very junior, but we became friends, and his area sounded very interesting. We started talking, and eventually he had an opening. Section was very small in those days. There were only, I think, 4 people in the section: Jeff Friedman, Jane Goichman, who was my predecessor at the Colorado River Board, representing the Colorado River Board, and a couple of other people. And when one of those other people left, I was hired for that position in January of 1973.
And you were in LA?
I was always in LA. We were at various locations. When I started working, we were at 217 West 1st Street in the old State Building, and the Colorado River Board, we were on the 4th through, 8th floor. I was on the 4th floor. The Colorado River Board was right below us on the 3rd floor. And almost immediately, well, let me go back. When I was hired into Public Resources, and I was interviewed by Carl and several other people, somebody in the interview, it was probably Carl, said to me, we know that you worked with Indians in Guatemala, and you undoubtedly have sympathies, and he knew that already. And it's very possible that when you come into the AG's office, you will be assigned to work at least part-time on the Arizona-California litigation, in which it's very possible that the state will be taking positions contrary to those of some of the Indian tribes along the river. Now, will that bother you in view of your history in the Peace Corps? Of course, I gave that great lawyer answer that, of course, it would, I could rise above that, et cetera, and they hired me. And I don't know. Hopefully, I'm sorry.
Probably point out early on here that Carl Barranque ultimately became general manager at Metropolitan Water District. And we don't need to cover his career here because there is an oral history of Carl Barranque on file that people have access to. But just so they can make the connection. Right.
And Carl hired me in, and as I say, in January of 73. He left in June of 76 to go over to Met as the assistant general counsel under Bob Will, and then became general counsel and later general manager. But my association, and we can get into this later, my association with him didn't end at the time he left the AG's office, because he was one of the 2 lead attorneys in the long Arizona versus California trial in 1980, in which I was representing the state of California. So we worked together probably more closely when he was at Met on the same case than we ever had when he was my official boss. He still acted like he was my boss when he was at Met, and he never got past that. But anyway, that's beside the point. Anyway, he hired me in, and one of my first assignments was to be backup to Jane Goichman. I think maybe she was Jane Liebman then. She was married around that time, and she was counsel to the Colorado River Board. And I was her backup. went to a lot of meetings with her. It was, at that time, we just had to walk down one floor, and the meetings were held there. And then when she left the AG's office in August of '74, I became lead counsel and remained so until I retired in February of 1991.
In addition to, I don't want to spend a lot of time on this, but in addition to your Colorado River Board responsibilities, as part of the AG's office, certainly you had other responsibilities in the AG's office. Could you cover those briefly so we know what you did with the rest of your time, and then we'll move on to Colorado River?
Well, let me say going in that I became of the opinion after some time that the Colorado River Board could have used a full-time attorney assigned to them. There was probably enough work, but I was assigned to them maybe a quarter of my time, a third of my time at most. That included the Arizona-California case. We had a ton of clients in resources, and the name of our unit changed over time, but the clients basically stayed the same. We represented just about every state agency that had anything to do with natural resources, except the State Lands Commission and later the Coastal Commission. Though we represented the Coastal Commission in the early years. That was one of my main clients. I sat with the commissions in San Diego and Santa Barbara at all their meetings and handled a lot of their cases. We gave up that client in about 1980, but we had clients that we maintained the whole way: the Air Resources Board, the Water Quality Control Boards, Fish and Game, Parks and Recreation, Forestry, Food and Agriculture, later on, all of the state fairs. God, we have so many, I'm forgetting them. But I had cases from all those different agencies at various times and acted for a few of the agencies, like the Coast Commission, that initially didn't have House counsel, just as the Colorado River Board didn't either. We acted as not only as their attorneys for litigation, but also at their meetings. What was I going to say? I lost my train of thought.
Well, you're moving through the various agencies that
Yeah.
you had.
But in 1978, late 1978, I was made lead deputy of the Natural Resources section in Los Angeles. It wasn't a job I applied for, but there had been a problem with the person who was in that position after Carl left the office. And so I was, our statewide section head, Bob Connett, who succeeded Carl when Carl left, put me in as the lead deputy in the Los Angeles office, and I had anywhere from 8 to 10 attorneys most of the time. And I served in that position for the remainder of my career there, which really took up at least a third of my time, maybe sometimes more. So I had a somewhat lighter caseload than the other people, but I always kept the Colorado River Board. And almost immediately after Jane Goichman left, we had a new attorney that came in, Emil Stepanovich, and Emil was my backup on the Colorado River Board for years until he left the office in, I think, 1987, I believe it was. And he worked a lot on salinity control issues with Ernie Weber. That was his sort of special area with the board. But I was lead counsel of the board basically for the next 27 years.
Would you say, Doug, that was by choice or just happenstance? I mean, was water law an area that you gravitated to out of interest, or it just happened?
Well, as I said earlier, I took a course in water law in law school. I happened to like Charlie Myers. I think he was my favorite professor. It was just an interesting area to me. When I came into the AG's office and got into Carl's section, we probably talked about it some, and he made the assignment. I don't know that I asked for the Colorado River Board assignment, but he made it. And he also, at the same time, one of the earliest cases I had was a groundwater case, the Tehachapi Cummings Irrigation District and our client up there was the prison, where there were groundwater rights, and I got really involved in that in the appellate phase of a case that other people had tried. And I guess I did well enough on it that he figured I could keep doing this. And of course, then when Jane left, I just automatically took over the board, and with it, the Arizona-California case, which I'd already been working on, and I know you'll get into the subject matter of that. But I don't know. It was an area that I think Carl knew me well enough to assign me to, but I liked it immediately. Always liked it. Always enjoyed it. It was always the most interesting thing that I did, because it was both legal and political and historical. It wasn't just litigation, and it was rarely litigation actually, and never ending, of course, as we all know.
In representing the board, and dealing with, Arizona v. California and other water issues, how would you characterize the level of oversight out of the AG's office, the Attorney General's office? Were you pretty much on your own and you became the expert, or, closely monitored?
Are you saying how much oversight I had within the office, or how much oversight we did of the board? I'm a little.
Let's do it both ways.
Yeah, okay.
I'm interested both ways. I'm interested in the level of autonomy that you had within the Attorney General's office, and I'm interested in what kind of direction you provided to the Colorado River Board and the association,
Right.
or I'm sorry, and the Six Agency Committee over time. So let's deal with the first question first.
Well, actually, that's a real interesting question. And I don't know that, I think Myron Holbert knew this, but when the first 10 or 15 years that I worked on the Arizona-California case, that was a different billing item than representing the board itself, because the Arizona-California case was really a state case. It wasn't, the board wasn't really the client. The board had a great interest, but the board wasn't really the client. And for years, we billed the case to the Department of Water Resources, but we never consulted them. We virtually never consulted them. I consulted Myron, who was, of course, the authority on everything. And
we should state, for the record again, Myron Holbert was the chief executive officer.
He was called the chief engineer in those days.
The Colorado River
Board.
Eventually migrated to Metropolitan Water District, and retired from there. And Mr. Holbert also is a subject of a separate oral history that people can have access to.
Right. So I would say for most of the time I had very little supervision, either from the client that was being technically billed, the Department of Water Resources, or within our office. When Carl was there in LA, which was the first couple years that I worked on the case and worked with the board, Carl knew enough about the case that there was some level of supervision, although we weren't in heavy litigation phase at that moment. But when Carl left and Bob Connett became head of the section, he was in Sacramento. He knew nothing about the Colorado River, or had known nothing except what I told him. And when the case went up to the Supreme Court in 1978, which I know we'll get to later, ordinarily in our office, I think a senior person might have taken that case away from me and argued it. But Bob Connett knew that he didn't really know the case as well as I did, and he didn't try to take it away, which I certainly appreciated. So I had very little supervision from within the office or from our client. At some point in the 1980s, the Department of Water Resources suddenly started paying attention to the fact that they were being billed for everything I did on Arizona, California, and wondered what the heck was going on. So at that point, we converted it to an AG's case. We billed it to ourselves. It was an Attorney General's case because it was brought on behalf of all the people of the state of California. It wasn't brought just on behalf of one client agency. And of course, the Colorado River Board really isn't authorized to bring suits anyway under their enabling statute. So it was an AG's case. And even when it was, though, I didn't have much supervision. Under the current regime, under Bill Lockyer, and when Rick Frank took over our division, our public rights division, was two notches above me. I think there was an attempt to make the case a little bit more responsive to the office, assuming that would have made any difference. I don't think it would have. But that was right around the time I left. So I really was pretty much on my own on that case for almost forever. But I was always working with the other parties who were involved, most particularly Matt Coachella when we had the lawsuit, the trial, and also the states of Arizona and Nevada. So we were sort of a check on one another. I know later on, I think you're going to ask me about, did our views ever differ and what happened? There was one time, well, maybe I shouldn't get into this now. I think I'll wait. In terms of your second question, how how much sort of hands-on authority did we have over the board? I would say pretty little, not much. When Myron was there, I mean, Myron ran the board. There was no doubt about that. And at those days, he and he knows this. He usually figured out what the law was himself. I think the time that he asked me for the most advice was when we started getting public members on the board, and he asked me once how I thought he was doing in terms of how he was dealing with them person to person and getting along, because and maybe I'm getting ahead of myself here, but in the first few years that I represented the board, before Jerry Brown became governor, and let's see, he became governor in 1974. Well, it was almost right away. But in the first couple of years before the Brown administration had really begun its sort of somewhat concerted effort to abolish the board.
You're talking about the Jerry Brown.
The Jerry Brown administration, yes. The board had 6 members: DWP, MWD, San Diego City and County, Imperial, Coachella, and Palo Verde. Just 6 members. And then Myron was the executive director, and Harold Pellegrin was the executive secretary, who actually was the only exempt position under the state statute. Myron wasn't the exempt position. That was another interesting little fact. Anyway, in those first few years, and I don't know if you want me to go through the personalities at this point, but Myron, those meetings were so short, they never lasted more than 50 minutes. Myron ran the whole meeting. There were very few questions. He was on top of everything. And pretty much everyone was of the same mind, it seemed. I mean, there was very little dissent that I can recall. And a lot of the people were, like Joe Jensen from MWD was quite old and didn't have a lot to say, although he was certainly there and obviously a force. But in terms of the meetings, really, they were almost non-events. It was like Myron just reporting, and there was sort of rubber stamp for what he wanted to do. And of course, Myron was always totally on top of everything. And so he wasn't used to many questions. And at that time, I was fairly new, but we would discuss things. But, I mean, in terms of us really having much authority or even trying to exercise it over the board, it was pretty minor, at least as to the board functioning itself. On the litigation, which at that time we were trying to get the present perfected rights decree entered by the court. And I know we probably want to go there too. But as time went on, and well, maybe I'm getting too far ahead here as to how the board changed and the introduction of the public members. And
No, actually, I think you're right on target in terms of a kind of change that happened at the board that changed the dynamics of the board.
yes, absolutely.
And I suspect maybe changed the relationship of the board.
I'm not sure that so much, but certainly changed the dynamics of the board. During the Jerry Brown administration, there was an effort made to abolish the board. I think the thought was there was no need for a separate board. It was technically under the Department of Water Resources, but it was sort of out there operating independently. It was made up of all these individual agencies that took water, and to some degree, I guess the feeling was that it maybe didn't always represent the welfare of the state as a whole as much as it represented the welfare of the 6 agencies. And there were all kinds of political things going on. And of course, most of these people on the board were pretty conservative, and the Brown administration was pretty liberal. It was just, there were a lot of issues, but there was an effort made to abolish the board. And what came out of that was a compromise where the board was allowed to continue to exist, although even at that time, the 6-agency committee, made up of the 6 original members of the board, was formed to contribute some of the funding to the board's annual budget. I think when I first associated with the board, it was maybe 1/3 of the board's annual budget. I may be totally wrong on that. But that's why the 6-agency committee basically existed, was to funnel the money in to support the board. And then the state supported the board 2/3. Gradually over the years, the percentages changed, so that now the 6-agency committee contributes, 80%? Almost all now, I think, because with the new budget, I think the state has withdrawn all funding.
Right, As a matter of record, in
Right.
2003, the state withdrew,
Right, which
was 20%.
yes, it had gotten to 20%, and I think that actually, in my view, has very ominous implications. I mean, I think when the state isn't supporting the board at all, well, I won't get into that, but
Although, again, just for the record, it is an agency of the state.
absolutely, absolutely, it is an agency, and that's why I think for the state not to support it at all is not right. But anyway,
Can you think, I don't want to get you too far off track, Doug, but can you think of another agency of the state of California where the employees are state employees, and where they take direction from a state agency, in this case, resources? Is there another agency that is completely funded?
I don't know. I don't know. On the other hand, I don't think the Colorado River Board, in my experience, took many directions from resources either. I mean, vaguely, but I think it was pretty much out there. Anyway, getting back to the Brown administration, the attempt to abolish the board, I think one of the compromises was that the six-agency committee percentage of the board's budget was raised. But perhaps more important than that was the fact that 5 new members were added to the board, to the additional 6. 3 public members to be appointed by the governor, and 2 ex officio members who served on the board as a result of their office, namely the director of the Department of Fish and Game and the director of the Department of Water Resources. Over the years, that changed. The number of public members decreased from 3 to 2, so that now instead of 11 members of the board, there are only 10. And often the public members are not visible or present, but that's another issue. And they rarely get changed with new administrations. I don't think soon-to-be ex-Governor Davis ever made an appointment to that position. I think the people that are holding that position were the ones that were there under Governor Wilson, although one has now resigned and the other hasn't attended a meeting in several years. In any case, that was one of the changes that was made, the compromise with the Brown administration to keep the board alive. And also, another change that was made was that the board was no longer given the authority to elect its own chairperson. And the chairperson for years had been Ray Rummins from Coachella. But during that compromise, the governor, as I recall, was given the authority to appoint the chairperson. So he appointed Patricia Nagel, who was the representative from DWP, Department of Water and Power, City of LA. He also appointed, and if I'm not mistaken, the 3 original public members. Well, actually, I haven't gone through all the members of the original board yet either, but there were 3 public members in that first board. A woman, I think her name was Helen Burke from Berkeley. She was kind of an environmental activist. There was Sandy Smith, who was a Native American attorney, member of one of the Ute tribes, and then Milt Nathanson, who was the just retired interior solicitor in Riverside. They were I believe, the first 3 public members of the board. There have been others, obviously, since, and as I said, the number of public members has declined from 3 to 2. But that was the compromise made, and suddenly the board meetings had these 5 additional people there who weren't from the 6 agencies, and some of whom were asking, especially Helen Burke, I remember, asked a lot of questions that, who knows if they were good questions or not. I'm sure that initially they weren't met with total receptivity by the old guard at the board, but, that was the way it is, and that was the way it was supposed to be. And I think for Myron, it was a new ball game, because suddenly people were asking questions in the meetings, and some of them were kind of aggressive at times, although over a period of time, what happened was that he knew so much more about what was going on than any of the new people, except, well, Milt Nathanson knew a lot because he'd been working in that area, but he didn't ask a lot of horribly leading questions either. So it was a different dynamic. And of course, there was a different chair of the board. And it was a woman, of all things. My God, I will say this on the tape, because I don't think you're interviewing Jane Goichman. But when she was counsel to the board before I was, there were a couple times when she was sort of excluded from things, from board, like extracurricular board functions, because she was a woman. I mean, it was an old boys network. There was no doubt about it. And you used to go to meetings, and there would be jokes told, not at board meetings, but at like outside meetings, and things were told that, you know, they weren't horribly obscene or anything, but they were a little shady, and you know, they're things that just wouldn't have been told probably to a mixed audience, mixed gender audience. So it was a different, the world was changing, and the Colorado River Board slowly was changing with it. I said at my retirement lunch a couple of years ago that the word environmental or environment was almost sort of a bad word to use at the Colorado River Board in those early years. I mean, it truly was. There was just, it was a very narrow focus, and it changed a lot over the years, and the board changed with it, and
Well, a later appointment to the board was, speaking of environmentalists, was Tom Graff.
oh, right, yes, Environmental Defense Fund, right.
And my guess is that while the dynamics were changing, he probably kind of put that in the fast lane
Yeah,
to some degree.
to some degree, yeah. But I think to some degree, people like Tom, and I don't want to get into too much into personalities here, but I think to some degree, people like Tom or like Helen Burke made their points, but in the final analysis, they didn't really control the votes, assuming that it came to that. And I think to some degree, they kind of made their points, and then they faded a little into the background. I don't think they were ongoing power bases on the board. I mean, the board still basically functioned as it did in the final analysis.
Right. And they, the people that you're talking about, the public members and the two ex officio members, they were not and are not represented on the 6 agency committee.
That's right.
And some functionary events go on there that do impact the board.
Right. And in fact, we did not represent, the Attorney General didn't represent the 6 agency committee or the Colorado River Association. And when I joined the board, Jane, as I recall, and I always did, when the board meeting ended and the 6 agency committee meeting convened and the association meeting, I would get up and leave the table. Now, in the later years, that blurred a little, and I would just stay at the table and not say a lot. And occasionally they would ask me questions, and I would say, well, you know, you really need to refer to your own agency counsel on this, because this isn't my job. These were not state agencies, and our job was to represent the Colorado River Board, not the 6 agency committee or the Colorado River Association.
It would probably be helpful, Doug, to define those 3 entities, because as you will describe here, they are blurred.
Yeah.
The 3 entities are the Colorado River Board,
which is an agency of the state of California under the Department of Water Resources and within the Resources Agency. Right.
And then you've got the 6 agency committee,
right, which is made up of Imperial, Coachella, Palo Verde, San Diego, LADWP, and Metropolitan. As I understand it, its main function is as a conduit for the agency contribution, money contribution to the Colorado River Board budget. That I understand is its main function.
And that board of those 6 people are the same 6 people that sit on the Colorado River.
That's right, that represent their agencies in the Colorado River Board. Okay. Right. And then the Colorado River Association is also the people, as I understand, from the 6 agencies, the same people, but that's sort of the public relations arm of the board and the 6 agency committee. And they're the ones that would put on the tours of the river, and you were quite involved with them, I think, weren't you, at one?
I've been involved with them.
Yeah. Right. Always.
All right, let's change subjects, move on from there. One of the things that occurred to us while we were putting together a little outline here is that you were in the Attorney General's office, which in a general sense represents the state of California.
Mm-hmm.
The state of California is made up of lots of agencies.
Mm-hmm.
There are water issues that occur where all of the agencies of the state of California are not necessarily together. And I'm not look. I don't want you to get into personalities and dog fights and whatnot, but I am interested in you talking about how the AG's office would resolve those kinds of conflicts where you've got agency A of the state of California thinks we ought to go this way, and agency B of the state of California wants to go some other direction, and you're representing both of them. And then let me put a name on that. Let's assume, just for the sake of discussion here, that we're litigating Arizona v. California, and Department of Water Resources or the Colorado River Board wants to go in one direction, and say Metropolitan Water District, which you did not represent directly, but still they're a California Water Agency, wanted to go in another direction. I don't even know if that occurred. It's not important. What is important is how does the AG's office balance all that stuff and
Well, that's
and take a course?
I think there are two questions here, and let me try to. One is conflicts between state agencies. The other is conflict between the state as the main party in Arizona, California, and Metropolitan, or one of the other parties in that case. So I think those are two different issues. To my knowledge, I can't really remember an instance where some other state agency wanted to take a different position than the Colorado River Board. There were instances, and later in the Lower Colorado River Multi-Species Conservation Plan, is that what it's called? Where Fish and Game is a major party to that. They also were ex officio on the board. And there certainly was a potential for conflict there because they have somewhat, to some degree, somewhat different interests. But I never really got into that. Within the AG's office, when there's a conflict between clients, we try to resolve it. If we can't resolve it, the AG will usually take the side of one client and authorize the other client to go out and hire outside counsel. And that's the way that usually works. I'm not sure how to get a handle on all this. In terms of the conflict between our office and some of the members of the Colorado River Board, I mean, it's sort of messy in a way, because here we're counsel, the AG is counsel to the Colorado River Board, but it's made up of all these different agencies that have their own counsel and their separate parties, particularly in a lawsuit. There was one instance. I'm trying to get a handle on the question. There was one instance which I remember vividly. The trouble is I can't remember what the particular issue was, but it was at some point in the Arizona-California litigation where we were clearly opposing the additional claims of the riparian Indian tribes along the Colorado River. And maybe I was in my politically purist phase, I'm not quite sure, but it occurred to me that even though the tribes were certainly, the U.S. was their trustee and had a special relationship with them and represented them, the tribes were nevertheless, they were citizens of the state of California. And I didn't see at one point how the state could continue to take sides with one entity in California against another when there wasn't some very compelling reason. And anyway, I remember going into, in fact, it was a meeting at Met over on Beaudry and Sunset. Myron was there, and I can't remember if Myron Hobart was then at Met or he was still with the Colorado River Board, but I remember Bob Conant was there from our office, and I was there, and we basically announced that we were going to take a more neutral position in litigation, which meant kind of backing off. And I really don't remember when this was. It must have been after, I think it was after the big trial before Special Master Tuttle, and it may have been during the trial in the boundary phase of the case. I just don't remember. All I know is it set off this incredible firestorm among the 6 agencies and led by Myron, saying, you know, you've always been on our side on this. I mean, the overall interests of the state of California, and certainly the overall interests of the then 12 million people in Southern California who get their water through Met, is more compelling than these interests of these little tribes, and they're represented by the U.S. And besides, since you've always been on our side, and if you suddenly became neutral, it looks like you've abandoned us, and you think we're wrong, and they went on and on and on, and we realized that we had probably made an error, and we kind of backed out, and we finally resolved it in terms of saying, well, we really could make a decision, sort of parens patriae, as to what was in the best overall interests of the citizens of the state of California. And after all, these tribes already had quite a bit of water from the 1964 decree, and there were very valid arguments on our side. So we eventually came back into line. But that was the only time. We had one other time.
Well, let me.
Yeah.
I'm going to come back to that one other time. Let me see if I can put a timeline on this. Do you remember who was general counsel at MWD?
No, I don't remember. I just, this is very vague. I had probably a file somewhere that could tell me this. Bob Conant might even be able to. I think it was after the trial before Special Master Tuttle. I'm pretty sure it was in the boundary phase, and at that point, I guess Carl was probably general, or no. Well, if Carl was general manager, Carl Bronte, and Warren Abbott was general counsel. I don't remember.
Okay, so
yeah.
I thought maybe I could get you to picture the people in the room.
I can remember Myron, and I can remember Bob Conant, because Bob and I we kind of had to back down at a certain point.
Okay, well, all right, so I interrupted you. You had said...
Well, there was another case which didn't specifically involve well, there's several other cases I could talk about. One was the acreage limitation case in the Imperial Valley, the 160-acre limitation case, in which the state had gotten involved under Governor Reagan through Ed Meese, who was his chief of staff then, got us involved before I ever even joined the AG's office, on the side of the Imperial Irrigation District, which was fighting, the U.S. and this guy Ben Yellen, to basically enforce the 160-acre limitation under reclamation law, and Imperial had O'Melveny and Myers as their attorneys. I mean, they weren't messing around at all. And here we were, the little state. We came in, we took a fairly narrow position in support of them, which is that that not so much that the acreage limitation should or shouldn't apply to Imperial for a variety of reasons, but that there'd been a letter from the Interior Solicitor to Imperial in 1933, basically telling them that the acreage limitation didn't apply to them, and that they had relied on that for, at that time, 40 years, and that it was unfair then to, this federal government should have been stopped from suddenly enforcing that limitation against them so many years later after they had relied on a solicitor opinion. And that was the position we took. But I really felt down there that was another situation that involved small-time farmers, small people that apparently wanted to break up some of the large holdings in Imperial. And of course, those small people were citizens of the state as much as the large farmers and the Imperial Irrigation District. And I just felt, again, that the state was probably taking sides where it shouldn't. And I tried to get us to basically back out of that case at a certain time. But George Deukmejian was, Everett Younger was Attorney General then. And I don't know if I should say all this. I guess I can. We were ready to back out, and I think I had some support within the office. But O'Melveny came in, and they put a lot of pressure on the Attorney General. And there was a big meeting, and because O'Melveny, as I said, was representing Imperial. I think it was Imperial, or maybe it was some individual farmers at Imperial. I have to think about that. I don't want to misstate that. But there was a big meeting, and the Attorney General decided that we should stay in the case. And in fact, told me that if I was very uncomfortable with that, they could reassign it to someone else. I don't know if that would have been a bad mark on me if I had agreed. But I said that I could stay in and write the argument, tailor it in a narrow way. But that, of course, didn't specifically involve the Colorado River Board as such, but it certainly involved Imperial. The other case I remember was...
Wait a minute.
Yeah.
We'll get there.
Sure.
I need you to define for us the importance of the 160-acre limitation. who cares how much property I own?
Well, I think the point was that it was that under the Reclamation Act, the water that came there was, I forget if it was free or extremely cheap. I'm vague on this, and I don't want to
It was
misspeak.
it was
Extremely cheap. Right.
It was developed.
Right,
by the federal
and
government.
it was felt that it shouldn't be benefiting just these huge land holdings, and that there was some interest in preserving the so-called family farm, and they thought somehow that 160 acres was as much land as anyone getting this benefit under the Reclamation Act through reclamation water should be able to farm and still get that benefit. So it was an effort to, I think, to maintain the small family farm and not just have everything gobbled up in huge agribusiness and corporate farming. And whether or not, and that issue has obviously been important other places too, like up in the Westlands, up in the San Joaquin Valley. And
So one issue, I mean, the compelling issue is that if you correct me if I'm wrong, if you as an individual owner owned more than 160 acres, that was okay, but you could only get Colorado River water for the 160 acres, not for anything beyond that. Or is that oversimplified?
Something like that, but I'm not sure. Now it's very hazy. This is almost 30 years ago. Maybe you could have gotten Colorado River water, but not at the
not at the lower price.
The lower price. I'm just not sure. I mean, it was certainly a threat to the big farms. I mean, if that had been enforced, there was no question about that. And the small farmers said, we should have a chance. Everything's been gobbled up by the big farms.
Well, tell us what the outcome of all that was before we move on.
The outcome was that the court upheld the court ruled against the small farmers. The court upheld the non-applicability of acreage limitation to Imperial. And it wasn't necessarily in our argument. It was on a more detailed argument that it simply shouldn't apply to them. And, at this point, this is real hazy. I remember a lot more about Arizona, California than that, because that's a long time ago. The other case where that I just want to briefly mention is the wastewater case that was brought by this farmer Elmore, who made a complaint to the State Water Resources Control Board about Imperial's unlined canals, wasting water, causing the Salton Sea to rise and flooding his farm, which was near the sea. Complained to the State Water Board, which is also our client. The State Water Board brought a suit against Imperial for wasting water, and I specifically took myself as far away from that as I could because of representing the Colorado River Board and Imperial being on the board. And the case was handled by a deputy, Ann Jennings, in our San Francisco office, and I kept out of that completely. Of course, that didn't specifically involve one of our clients versus another client, but it did involve one of our clients versus a constituent member of the Colorado River Board. So that was, and there have been other issues too. There have been a lot of issues, I know, between Fish and Game and Coachella and Imperial on various things with the Salton Sea and other items. I know when the Coachella Canal was going to be lined, there were environmental concerns about suddenly cutting off all this water that was leaking out and supporting various habitats along the canal, and there were issues there. But I stayed clear of that because, again, that it was too close to the client. I mean, the whole thing, though, was the fact that the Colorado River Board was made up essentially of these other agencies that had issues with other state agencies always made it kind of a blur. It was a little bit of a messy situation. I just stayed as clear as I could from our other clients, who I represented in other cases, Fish and Game, the water boards. I mean, they were my client as much as anyone else's, but not in those issues that involved constituent members of the Colorado River Board.
Speaking of IID and the Elmore suit, was there an issue or a dispute that caused IID to decline to participate with the board? I
looked at the outline obviously before we came into this, and You know, I think there was, and I'm trying to remember. There was a time when IID wasn't sitting there, but I can't remember what that was about. I just can't.
Okay, well,
I blanked on that.
we'll,
Yeah.
we'll cover that when we talk with the folks down at I.
Yeah.
See if they can bring it up.
Right, right.
Uh,
Did you I don't want to move you back or interfere with your order here, but did you want me to talk about the people who were on the board originally? And because I think we went past that.
well, we covered some of those.
I don't think we mentioned all the people. I mean, the original board, when I was there were only 6 members. There was Ray Badger from San Diego City and County Water Authority. There was Carl Bevins from,
Okay,
I'm sorry.
Let me
Sure.
stop you there because the San Diego entity is commonly referred to as San Diego County Water Authority, and you have used the phrase city and county, the San Diego. City
Okay,
and
I'm
County.
sorry.
And so I'm wondering, is there some legal nicety there that I'm
The-
missing? Or?
They were originally, in the original Arizona, California lawsuit, I'm almost certain of this, there were 2 separate parties, San Diego City and San Diego County. And at some point, they merged into the County Water Authority or something, and they became one party in the suit and one party on the board. Now, I don't know if they had 2 representatives on the Colorado River Board at one time or not. Certainly when I was there, there was one person representing both, and that included the city and county. And,
Okay.
and what they were called, yeah.
I just wanted to clarify.
So Ray Badger was the representative from San Diego. He's a very elegant older man, very tall, gray-haired man. Didn't say a lot. Carl Bevins from Imperial was there for quite a while, but he died very suddenly and was replaced by Robert Carter, I think, who was their general manager at that time, and he was there for many years. Virgil Jones was always there and was there my entire tenure.
From PVA.
From Palo Verde Irrigation District, and of course Virgil became chair of the board when Ray Rummins died in 1998, I think it was. And Virgil was there when I left, and of course, unfortunately, he died, a year and a half ago. But Virgil was a wonderful man, a perfect old salt of a farmer. He'd come from New Mexico after the war, and I think he's from Las Cruces, New Mexico, and settled in the Palo Verde Valley in 1947, and had been there for years and years, raising, I guess, mainly cotton and alfalfa, if I'm not mistaken, maybe some other vegetables. And he was truly a farmer, and he was a farmer to the end. And he died out in his fields, loading something or other, I don't know. Ray Rummins from Coachella was the chair of the board the entire time I was there, except for those few years when, as I said earlier, Patricia Nagel from DWP was appointed board chair by the governor, by then Governor Jerry Brown. But at some point after that, the statute was amended. The board was again, I think that was when the number of public members on the board was cut from 3 to 2, and the authority for appointing the board chair was returned from the governor to the board. And also, I think the governor was required to appoint board members, but from a group of people submitted by each agency. Anyway, after the authority to pick its chair was returned to the board, Ray Rummins became chair again and served as chair until he died. He was from Coachella. I think he was a realtor more than a farmer, if I'm not mistaken. And he was real political, and he was involved in a lot of, I think he had some position with, was it the Colorado River Water Users Association too, or some other?
He was president of the Colorado River Water Users Association at one time.
Right. And then I have forgotten who was the representative from LA Department of Water and Power at that time, but the representative from MWD was Joe Jensen, who was definitely a legend. By the time I got there, he was quite an old man, although he actually seemed to me a lot older than he was. I know he died, he was 87, and I remember thinking that he seemed much older than that, because he was very quiet. He was pretty quiet in the meetings and didn't say much, and he was I think a little past his prime by then. But I just remember his face was almost waxen and white. I mean, I would see him at these meetings, and I thought, my goodness, how old can this man be? Of course, I had no history with him when he was the real powerful force at MWD, and I guess with the board too. By the time I got there, he was he was there, but he didn't contribute a lot.
He,
But that was,
he was chairman of the Metropolitan Water District's Board of Directors.
I don't know if he was chair of the board at the time I was there. I
Well,
think he,
at one time.
yes, at one time he was, I'm sure, yes.
I believe he represented the city of Los Angeles on Metropolitan.
That I'm not sure of. He died within 2 or 3 years after I started working with the board, and was replaced by, was it Warren Butler? I think initially, yeah, and then a series of other people over the years. But that was the original board, and they were, I mean, it was a fairly old board, to say the least. The age has gotten lower as time has gone on, and there have been a series of very interesting people there over the years. I could probably go into them, but
Well, I
Anyway.
do want to get into
Yeah,
personalities
yeah.
a little later. I think what I'm going to do now is take the opportunity to pause and
Okay.
change tapes.
sure.
Pick this up in just a minute. Okay, this is tape number 2. We're with, pardon me, we're with Doug Noble, November the 5th, 2003. We took a pause. At the end of tape 1, we were talking about some of the people who were on the original Colorado River Board of California. And I suppose we probably should move on at this stage of the game. I don't know, there's probably no easy way to jump into Arizona v. California and the boundary case and whatnot. Let me ask you, where is a good place to start with regard to those particular pieces of litigation?
Probably with what I first got involved with when I came into the section, which was the Present Perfected Rights Decree, which when I entered our section and went to work at the Colorado River Board, or for the Colorado River Board, the board was, and Myron Holbert specifically, because he was chief engineer at the time, was trying to get an agreed upon, what's the word? Supplemental decree to the court's decree in Arizona, California, listing present perfected rights. Now I'll try to define that.
Okay.
The original Arizona, California case, which was tried in the late 50s and early 60s, was a suit by Arizona against California, basically trying to figure out how much of the lower basin's share of the Colorado River under the Colorado River Compact Arizona was entitled to. Because Arizona had trouble getting anyone to support, or enough people to support, its plans for the Central Arizona Project in Congress until it knew how much water it was entitled to from the Colorado River. So it brought the suit against California, and various other parties joined, all the agencies from California joined. That case was resolved and was decided in 1963, and with a decree entered in 1964. Now, I'm sure other people have talked about that. I don't think I probably need to do that. But the basis of the decision in that case was that the court held that the United States Congress, when it passed the Boulder Canyon Project Act in 1928, had in effect apportioned the lower basin's share of the Colorado River between Arizona, Nevada, and California. But at the same time, the court said that people, users of water in the lower basin, that had been using water up to the date of that legislation may have established what's called present perfected rights. They had perfected a right to use that water, and that right was a presently perfected right as of the date of the effective date of the Boulder Canyon Project Act, which I believe was June 25th, 1929. So as part of its decree in 1964, the court ordered the United States and all the parties to the case, which was Arizona and Nevada, plus not only California, but the agencies, and I think Utah and New Mexico had intervened in the case too, but they didn't really participate in this, ordered all the parties to, within, I think, 2 years of the decree, to come back with a list of those people in each state who had present perfected rights, who had rights that existed as of the time of the passage of the Boulder Canyon Project Act, and those people would be, in a time of shortage, would be entitled to get water basically ahead of anyone else without regard to state lines, but with regard basically to their date of priority as to the date that they had perfected their right. Well, first of all, and this happened before I came aboard, first of all, the states were arguing over the various rights because people came up with lists and they argued over the list. And then I think finally the states sort of came together. But then the U.S., which was trustee for the Indian tribes, had some problems. The U.S. not only had claimed some present perfected rights of its own regarding federal establishments. There was like a wildlife, or I forget what it was called. I don't have the decree in front of me, but there was a wildlife refuge down there the U.S. had some reserved water rights for. But more importantly, the U.S. Represented the 5 Indian tribes as trustee along the river and had obtained for them over 900,000 acre-feet of water in the Colorado River that came out of the lower basin's 7.5 million acre-feet. And that hadn't really been apportioned as to which state it came out of, but that right was existing. The U.S., well, there were different issues involved as I came aboard, and we were basically trying to get the U.S. to sign on to the agreed upon list of present perfected rights that we could take back to the court. And we'd already passed the 2 years, and then they'd extended it for a year, but we were way past the deadline for submitting anything to the court. So the U.S., there was some feeling generated a lot by some of the Indian tribes, and particularly by a guy named Bill Veeder, who was an attorney for some of the tribes that, or I don't remember now exactly, but basically there was a feeling that the tribes had been shortchanged in the original lawsuit, that that this 900,000 acre-feet that they got was far less than they should have been entitled to. Moreover, there was the feeling that the then agreed upon list of present perfected rights that the states had agreed upon, which included a lot of rights in Imperial, not their entire contract right, but I think 2.6 million acre-feet to Imperial and quite a bit to Palo Verde, that somehow those rights were going to, if those rights had been recognized as present perfected rights in a time of shortage, they might somehow prejudice the 5 Indian tribes' rights along the lower Colorado River, the rights that had already been decreed, much less anything additional that the tribes were entitled to. And this was because the tribes said, well, there's this doctrine, or the tribes, and then the U.S. sort of picked up the tribes' argument. There's a doctrine of relation back that allows a priority date to be set from the date when an appropriation or a water course is first developed to take water from a water source. I'm really speaking very badly here, but the point is, let me go back. The tribes and the U.S. as their trustee were basically saying a lot of these state rights that are being listed as present perfected rights that the states have agreed upon have priority dates that are too early. And that's because of this doctrine called the doctrine of relation back, which gives you a priority date, not when you really started using the water, but when you started diversion systems, started building the means to get the water to you. And the tribes said the doctrine of relation back should not be applied vis-a-vis us because it gives these state entities water ahead of us and may screw us basically out of our water in time of shortage. Now, of course, the problem with the tribal water is that a lot of it wasn't based on actual use. It was based on a Winters Doctrine reserved right, which gives you a priority date as of the time the reservation is established, irrespective of whether water was actually being used. So this was all a little confusing, but the point was that the tribes and the U.S. basically held up the decree saying that the priority dates we were assigning, especially to the big people like Imperial and Palo Verde and some of the there were some municipalities that had present-perfected rights. That was somehow going to prejudice the tribes. And that's around the time when I was first involved. And how we finally solved it was basically we had a subordination clause. We agreed that in times of shortage, and we honestly couldn't see that this would ever happen, that there would never be so little water that we couldn't settle all the present-perfected rights, including the Indian rights. But so we felt really that we weren't giving away a lot, and we didn't really know why the tribes thought this was so important, because we thought they would be protected in any case. But to get rid of that issue, we agreed to subordinate all the major present-perfected rights, all the major state present-perfected rights claims to the Indian claims. In other words, the 900,000 or so acre-feet of Indian reserved right claims on the 5 reservations in times of shortage would be satisfied ahead of any of the major present-perfected rights claimants in the states, the non-Indian people, including Imperial, Palo Verde, whatever. We didn't include the miscellaneous present-perfected rights holders. There were a whole bunch of people that had the right to 1 acre-foot, and we couldn't get all of them to sign off on this. There were 40 or 50 of them at least. But the tribes were willing, and the U.S., as their trustee, was willing to accept this subordination agreement where we let the Indian rights be satisfied ahead of the major present-perfected rights holders. And that really brought the U.S. aboard and agreed with the entry of the decree. Now, as I recall, a couple of the tribes went along with that. And I'm getting a little hazy on this. A couple of the tribes went along with that, but several of them didn't. I think the Chemehuevis and the Fort Yumas didn't go along with it. Plus, all of the tribes at this time decided that since we had this agreement with the U.S. on this supplemental decree listing present-perfected rights and had to go up to the Supreme Court to have them enter the supplemental decree, that at the same time the tribes obviously decided, and the U.S. on their behalf decided that they would file a motion to expand the number of Indian reserved rights along the river based on this feeling that they had been shortchanged at the original trial. And that motion was made in 1978. And that's what's really kept this case alive ever since. The present-perfected rights decree, we argued, and it was entered by the court, and that was my Supreme Court argument, October 1978.
The United States Supreme Court.
The United States Supreme Court. But the other issue, the reopening of the case to assert additional rights for the Indian tribes based on 2 different theories, one on what's called omitted lands and the other boundary lands, which we can talk about. That's an issue that has remained open to this day, at least as to one of the reservations, the Fort Yuma. It still hasn't been settled 25 years later.
Okay, as long as we have the phrase right on the tip of our tongue, why don't we define, if you would, admitted lands versus boundary lands? What is that issue?
Omitted lands.
Omitted
lands. Okay, and let me say at this point, I hope I've explained present-perfected rights well enough. I mean,
well,
I should say also, and I know you're going to make a copy of this, that I did a whole separate tape myself 3 years ago on the law of the river in which I talked about some of this stuff. So maybe it isn't necessary to get into all of it now. But let's just say this. All this went up to the Supreme Court at once. The agreed upon decree on present-perfected rights, which the states, the U.S., and most of the tribes were in support of, and a couple of tribes, for various reasons, were opposed to, went up to the court at the same time that the tribes, now up to this point, the U.S. alone had been representing the 5 Indian tribes as trustee in the lawsuit and had represented them in the original trial and had been the architects of their claims, all of which were recognized, their water rights claims, but which some of the tribes now said were inadequate. So the tribes themselves asked to intervene in the case as parties so they could assert their own additional water rights claims. And the U.S. apparently was buying into this. They were supporting the intervention of the tribes, but they were also going to continue to represent the tribes and maybe also assert some additional water rights claims on the behalf of the tribes themselves. Okay, so we go up to the Supreme Court. Various people took various positions. There were 7 people arguing that day. It was incredible. I don't know. The court generally gives an hour and a half for oral argument, or an hour. This time they gave an hour and a half, and they allowed 7 people to argue. I went first. I was representing the state of California and the state of Nevada, and all the agencies. And I think I was speaking for Met too, although Bob Will, who was general counsel at Met, also argued. My position was, 1, the decree on present protected rights should be entered. 2, the tribes should be allowed to intervene to represent themselves in the case, but that there shouldn't be dual representation. In other words, the tribes should be forced to choose. Did they get represented by the U.S. as trustee or by their own attorneys? I think Met took the same position, I believe, but Bob Will can and has told you that already. Arizona argued, Ralph Hunsaker argued for Arizona, and they opposed the intervention by the tribes. They were, of course, in support of the PPR decree, Present Protected Rights decree, but they opposed the intervention by the tribes. Then the 4 tribal attorneys argued. There was Terry Noble Fisk, who was represented, I think, the Colorado River Indian tribes. Larry Aschenbrenner, who represented the Chemehuevis and the Cocopas. Ray Simpson, who represented the Fort Yumas, and they seemed to be opposed to everything. And who was the other attorney representing the Fort Mojaves? It wasn't Dan Israel. There's where I'm blanking. And Louis Claiborne represented the United States, I think as he always did. Anyway, that's right. There were just 3 Indian tribes represented: the U.S., Arizona, Met, and California. So that's the 7 attorneys. And I went first, and I was speaking for more people than anyone else was speaking for, but everybody had their speaking for whomever they wanted.
Now
So,
you said you only had an hour. Is that an hour total or an
hour and a half total. No, I had 20 minutes.
Okay.
Bob Will had, I don't know, 10 or 15. I don't remember, but
Okay.
Yeah. Okay, what happened was the court entered the decree. And I know someplace you wanted to ask me how I prepared for that. You can do that in a minute, I guess. The court entered the decree. They also allowed the Indian tribes to intervene as parties, but they didn't limit them to single representation. They let the U.S. continue to represent them too, which of course had a major, major impact on the lawsuit we had, because we were, as I'll explain later, we were faced with 2 different sets of claims, both on behalf of the Indian tribes. And then they also appointed a special master, Elbert Tuttle, of the retired Fifth Circuit, United States Court of Appeal for the Fifth Circuit out of New Orleans, although he was from Atlanta, retired judge of the Fifth Circuit, to be special master in our case, to hear the claims, the Indian and U.S. claims for additional water rights for the 5 Indian reservations along the river based on these omitted land and boundary land claims. And so that's what we're still working on. So the PPR decree was entered. That's what we really wanted. But then Pandora's box was really opened for the next 25 years. So
Well, tell me,
where do you want me to go?
with 7 attorneys, you're going before, was that the only argument that you made before?
That's the only one. I've been there 3 more times, but Carl argued once, Jerry Mize argued twice for Met, because, and we can get into this, but by the time we got into the 80s, it was real obvious that the main party with interest in what was going on was Metropolitan Water District, because they had the lowest priority under the 7-party agreement, and they were the ones whose ox would really be gored by additional Indian water rights. And so, it sort of naturally gravitated that they would be the lead party, but we certainly participated.
Can you define the 7-party agreement for us?
seven-party agreement was basically an agreement among the 7 parties in California, and I say those are the 6 members of the Colorado River Board that we've talked about before, plus at that time San Diego was both city and county, so that's the 7 parties. And they basically, now I have to make sure I'm stating this right, this was 1931, they basically set priorities for the water available to California, and it went beyond the 4.4 million acre feet, which was the figure talked about in the Boulder Canyon Project Act, but it did allocate the first 4.4 million acre feet. And when the court, of which Met got 550,000, the 3 agricultural agencies, Imperial, Palo Verde, and Coachella, were essentially allocated 3 million, wait a minute.
I think it's 3.85.
Right. 3,850,000 acre feet of water at the top, and then Metropolitan, within the first 4.4 million acre feet, got 550,000. Now, Met signed a contract later for over 1.2 million acre feet, but within the first 4.4 million acre feet, they were only having a priority of 550,000. But that priority is decreased by any present perfected rights, any present perfected rights other than those held by Imperial and Palo Verde, any relating to all the individual people, plus any reserved rights held by Indian tribes in California. Now, within California, I said earlier there was, I think it was 910,000 acre feet of consumptive use rights allocated to the 5 Indian tribes along the Colorado River. This was in the original trial. This is before you get to any additional Indian water rights claims. Of those 900,000 plus acre feet, most were in Arizona. So most would go against Arizona's share of the river, but about 150,000 maybe of those were in California. And those would go against California's share, and those would be satisfied ahead of anything else. And basically, since Met was the lowest priority and had only 550,000 of the first 4.4 million, those would come out of Met. Plus any additional water rights that the tribes would get with their application for new rights in 1978 for additional rights would also come out of Met, which is why Met is obviously the most interested party.
Okay, where do we want to go from here?
Well, do you want to talk about how there was some question about how did we prepare for the Supreme Court argument or something.
That was, in fact, I started into that a few minutes ago and I sidetracked both of us. My question at the time was that your first appearance, the first time you'd argued before the Supreme Court, and you indicated that it was.
First and last.
My interest is you had an hour and a half. There were 7 attorneys that had to squeeze their arguments into that time period. You don't ask the Supreme Court for a little more time. I mean,
we were lucky to get an hour and a half. That was very unusual, and lucky to have, and lucky for them to let us have more than one attorney on each side. It was very unusual.
Why do you think that was? Why do you think Supreme Court?
Because there were people with so many different positions, for one thing, and I guess they just recognized it was, it was a big case, and I don't know. Now it's hard to go back and try to figure that out, but
it was and remains an uncommon case.
Absolutely.
Because as of this day.
Absolutely. Absolutely. And my preparation for it was uncommon too, because there wasn't a lot of case law applicable to our case. Our case was kind of its own law, the law of the river. And so I didn't really have to prepare as much, perhaps, as most people do for Supreme Court arguments, because most of the law was within our case. I mean, there were some other things that applied. I ended up being the lead because we were on the side making the motion. We had brought the motion to enter the decree.
We, California.
The state parties. Nevada at that time was, they were represented by a guy who was younger and less experienced than I, And as I say, Arizona had a slightly different position. But California, we all felt that our position would be better if the state represented us rather than trying to get somebody from each agency, or maybe one agency of the 6 agencies speaking for California. Now, Matt entered, and and it's hard to remember now how this decision was made, but it was apparently a fairly obvious decision that California should take the lead. And I guess they had enough confidence in me that they let me do it. And then because Matt really had such an interest in the case, especially in the subsequent litigation with the tribes coming in, I think Matt felt the need to have Bob Will argue in addition. But he was basically, I think we had the identical position. I believe we did. As I said, Arizona's position was a little different. So it was just agreed that I would go first, and I guess we divided the time equally between the state parties, and then I guess the U.S. and the Indians took half of it. I forget how it was done. I'm pretty sure I had 20 minutes, Bob Will had 10, and Ralph Hunsaker had 5. I think that was the way it was. So there's 35 minutes out of the 90. No, we had more than, I don't know. Anyway, I have the transcript here. We could go back and check it. Anyway, and I might add, this is mildly humorous, and I don't know if you want all these little personal things, but it livens it up a little. We went back, and we certainly didn't stay in the lap of luxury. We stayed in the Quality Inn on New Jersey Avenue, right down the street from the Capitol, but also right down the street from Georgetown University Law School, which was very fortunate because the day before the case, I'm someone who usually prepares the last minute and is up late, but I felt so fully prepared, and I'd had a moot court within our office. Now the AG's office, whenever anyone is going to argue in the Supreme Court, has a very elaborate thing, and I think they send you back to the National Association of Attorneys General for a briefing and all kinds of stuff. But in our case, there were a couple things that were unique about this. One, I had planned a trip to South America for about 3 weeks right before the case, and the office said, well, basically, you can argue the case and go to South America, but you have to prove to us in your moot court before you leave for South America that you're okay. And various people in the office thought I was nuts that I could argue it after coming back from a trip, but I did. And then the other thing was that, God, I lost my train of thought.
Well, you're staying at a cheesy motel.
No, that wasn't it. It was, oh, damn it. Well, anyway, so we get back there, and I've had my moot court, and we stay at the Quality Inn. It was okay. And for one of the few times ever, I felt fully prepared by mid-afternoon. And I never take a nap. I never take a nap in the mid-afternoon. I may fall asleep in my chair at work by mistake, but I would never lie down and take a nap. I decided to lie down and take a nap. And I had no sooner lain down than the phone rings. And I think it was Ralph Hunsaker, who, as I said, was counsel for Arizona, saying, Metropolitan just called us, someone from Met called us. They couldn't get a hold of Bob Will, and they called me to tell me that we had just gotten a memo of 8 cases submitted by Larry Aschenbrenner, who was counsel for the Chemehuevi and Cocopah tribes, the last second to the court that he thought the court should look at and would be instructive on the case. And Ralph said, I've taken a look at these cases, and I don't really think they're anything. But I said, well, I think I better satisfy myself too and go look. So here I am, the last afternoon, thinking I'm relaxing. I raced over to Georgetown University Library, and I was there, I don't know how long. All I know is the first case I looked at looked extremely bad for us. These were cases none of us had ever come across. I mean, I don't know why we hadn't. Now I can't remember. All I know is the first case I looked at said something that was very damning to our position. And I thought, God, and it's getting late now. And I'm reading all these 8 cases. And I'm in the library, and it's a big social hour for all the students there, and they're laughing. And I'm panicking because the argument's the next morning, and we just got these cases. It took me to the last case of the 8 to distinguish the first case and answer it and basically put it to bed and gave us a good argument But I was there till like 9:30 at night. And so then what happens is the next morning, we go in early to meet with the clerk, and he needed some special help because this was Michael Rodak, who was clerk of the court then. He was a bit of an old lady in terms of being kind of fussy and very uptight, and he was just so concerned that there were this is incredible. There was the chair for each counsel at the front table, and then there were 2 other chairs at the table. But that's a total of only 6, 3 on each side, and there were 7 of us. And where was the 7th person going to sit? And I said, I'm going first, so I will go up to the lectern, and when I finish, I'll be glad to go back and sit in one of the other rows toward the back. And he said, oh, would you do that? He said, that would be so great. I would so appreciate it. I said, I don't care. I mean, I'm done. It was quite amazing. So we took a little tour of the Supreme Court Library, which was pretty exciting. But we talked to him about this late submission that I had wasted my anxiety over the night before. And he said, that's ridiculous. He said, I didn't even show that to the court. He said, I didn't even give it to them. I said, no. He said, much too late. Totally inappropriate. So that was it. So we go in for the argument. And ordinarily, even in those days, our office would send you back a couple days early to see another argument if you'd never seen one. I'd never been in the Supreme Court in my life. But this was the opening day of the October term. There was no other argument to see. So the only argument I saw was the case ahead of us that very morning. So we go in there and sit, and we're in what they call the on-deck circle, which aren't the rows at counsel table, but they're within the little separation box there, and they're around the side. That's where I went and sat after my argument, but that's the on-deck circle. And so we sat there and we watched this argument. The argument went on, and the one thing I noticed was that I had written my points out on, we were then using yellow sheets. We went to white much later because they were cheaper. But I was using legal-size tablets, which are 8.5 by 14. And Michael Rodak, again, the rather fussy clerk, made it very clear that that was really bad because if the sheets were too long, they overlapped the lectern and they hit the microphone and they caused interference. So fortunately for us, the first case didn't end at lunch. It was still going. So they dismissed us for lunch, and at lunch, I spent the entire lunch hour rewriting my notes on 8.5 by 11 so they wouldn't interfere with the microphone. So we go in after lunch, we're sitting in the on-deck circle. I thought I was very calm, and I know I'm talking about this too long, but this was an interesting experience. I always thought I was very calm, and that morning I ate breakfast, and I didn't have my usual, I have certain reactions to stress, but I won't need to go into those. But anyway, I thought I was very calm. But sitting in this on-deck circle waiting for the other case to end, I was getting really parched, and there was no water there. The only water was up at the counsel table. So when I went up, they called our case finally. I walked right up to the lectern with my notes, and I asked someone to pour me some water because I really was parched. And as I picked up the water, I realized for the first time how nervous I was because I was shaking so much I couldn't hold it in one hand. I had to take it in 2 hands and drink it. And then I started out, and I can't believe I said this, but the transcript probably doesn't lie. It says, I'm Douglas Noble representing the state of California in the case of Arizona versus Arizona. Oh. It's right in the transcript. I didn't make another mistake. I didn't misspeak on anything else, but I did that, apparently. Anyway, the argument went fine. They asked me, Stewart and White asked me, Justice White asked me some questions about this subordination agreement, where we had subordinated all the major present perfected rights to the Indian rights. And he asked some question which was kind of off the wall and didn't make a lot of sense, but he was being very persnickety, and I didn't quite understand where he was going, and I think I asked him a question back to clarify. And a good friend of mine, I made the serious mistake of not inviting my parents to see me argue, but I did have a good friend, an old Peace Corps friend from Washington, D.C., who came, and he was a the product of a very Catholic education that respected authority. And I remember him telling me afterwards how impertinent he thought I was to Justice White. But no one else apparently thought I was. So that was the argument, and it was an experience. I think I more enjoyed going back when I could just sit up there and watch other people argue in a case I knew all about, but I didn't have any of the pressure. But it was a once in a lifetime thing. Anyway.
And then to start off referencing the case erroneously.
Well, they knew what the case was, and I'm still not convinced that wasn't a typo in the transcript, which I have. These were when they were still doing these things in a mimeograph. It's all this sort of faint pink or purplish. Yeah. Very informal too. The court, in many respects, is very informal and hang loose about certain things, and that was one of them. Most transcripts you'd get are very formal and nice, and this was just sort of this thing someone had typed up and sent out. But anyway.
Do they redo those? This is kind of off subject. But for a permanent record, or are they holding the same mimeographed, horrible-looking purple copy that you?
I don't know, actually. They don't allow you to make corrections. That's for sure. It's not like a deposition or like this.
Yeah, that's interesting.
Yeah.
You had mentioned a special master, and I think we
Excuse me.
probably need to define what a special master is.
Yeah.
Specifically, there are two that I'm interested in: Tuttle and Rifkin.
Rifkin, yeah.
Who came?
Well, we certainly have had others. No, Rifkin was before Tuttle.
Oh, Rifkin was first.
He was the original trial, and I never knew him. He just died a few years ago. He was 92. He was the one that Charlie Myers, my water law professor at Stanford, clerked for. And that was Charlie's connection to the case, and led to some further dialogue with me later when I was working on the case, which was real interesting.
Okay. Well, I wonder if you could define for us briefly what a special master does, and then maybe talk a little bit about, do you call him judge or do you call him special master? Tuttle.
I think we called him judge because that's really what he was. He was a judge of the Fifth Circuit, or Your Honor. Well, this was an original jurisdiction case in the Supreme Court, because it was originally a case between two states. And in a case between two states, it is the Supreme Court alone that is the trial court. It has original jurisdiction. You don't get up there on appeal, you go there right away. Well, the Supreme Court obviously can't conduct what turned out to be an 8-week trial. I mean, they don't conduct trials. So when they have cases of original jurisdiction, they will appoint usually some very esteemed, often retired judge from somewhere that they know or have confidence in, or sometimes an attorney. Jerry Mize was a special master in a groundwater case between, I guess it was Kansas and Oklahoma and Colorado. Anyway, and as I say, I did not know Simon Rifkin. He was from New York, I believe, and he wasn't actually the first special master in the original case. The first guy was a guy named George Haight, and he died, and they had to start over with Simon Rifkin. But in our case, as I said earlier, the Supreme Court entered the Present Protected Rights Decree, allowed the Indian tribes to intervene as their own attorneys, but also kept the U.S. as their attorneys, and appointed Special Master Albert Tuttle, retired, or yes, he was senior status judge of the Fifth Circuit Court of Appeals, to be special master in our case for all purposes, basically. Judge Tuttle was quite an amazing man. He was known as one of the big 5 desegregation judges in the South, along with Frank Johnson, John Minor Wisdom. I forget the other 2. And in fact, there's a book written about the 5 of them, because they were in the school desegregation cases. They were just major, major players. Tuttle was, he was a Republican. He had helped deliver the Georgia delegate. He was from Atlanta, and he was an army guy, and he may have had some connection with General Eisenhower in World War II. I'm trying to remember. But anyway, he had helped deliver the Georgia delegation for Eisenhower at the 1952 Republican Convention when Eisenhower was battling Taft for the nomination. And he was active in Republican politics in Georgia, which of course Republican politics in Georgia wasn't much in those days, but it was enough at the convention. And he was appointed, he got a position, I think it was in the Treasury Department in the Eisenhower administration, some sub-cabinet position, which I've forgotten. Anyway, he was later appointed to, I think he was appointed directly to the Fifth Circuit. I can't remember if he was a trial judge. In any case, he'd been on the Fifth Circuit, operated out of New Orleans, but he lived in Atlanta. And as I said, he was one of the key 5 judges in the desegregation cases, which of course, his family was very concerned, about crosses being burned on his lawn. I don't know if there ever was one burned on his lawn, but there was, at those days in the 50s, things were pretty heated in the South. So here he was, the Republican, the pretty liberal Republican who'd made these very pretty courageous decisions, more than one of them. I truly believe, and not out of disrespect to him, in fact, he got the Presidential Medal of Freedom from President Carter during our trial and recessed it for one day and was very proud of it and had us over to his house later at one point when we were meeting in Atlanta toward the end of the trial. But I truly think that he subconsciously, whatever, had such a strong affinity to the view that the Indians generally had been wronged, and that most of the people that were fighting them in this case were fat cats. I know at one point he actually made reference to the fact that didn't most of the farmers in the Imperial Valley drive Cadillacs. I remember that. We had the feeling, frankly, and again, I say I don't want to say this out of disrespect to him, but we had the feeling that he really had somewhat prejudged some of this, that he gave the Indians more benefit of the doubt than maybe should have had. I mean, I know there's certainly rules about in boundary disputes or cases involving interpretation of documents that sometimes tribes are to be given some benefit of the doubt. But this was hardly that. This was basically, well, there were a lot of issues in this case, and we felt that in a way we got a little shortchanged. But, I mean, that wasn't to say he ruled in the favor of the tribe on everything. He certainly didn't. But he did conduct an interesting case. He was pretty military in his bearing, very formal, and but a very decent man. He and his wife, what was her name? They drove all over the country. He was 81 when he took over the case. He lived to be 97 or 98. Miss Sarah, that was her name, his wife. They drove everywhere. And basically the trial was held wherever he and Miss Sarah wanted to go. So we drove to, let's see, we had a month in Denver. Of course, we had preliminary hearings too, and I think some of them were in Atlanta. We had some preliminary things where we resolved certain issues, but the actual trial itself took place in Denver in September of 1980 for a month. Then we were in Phoenix for 2 weeks in December of 1980. We were in Atlanta for, I think, 9 or 10 days in the spring of 1981. And then we had a final session at the then Huntington Sheridan Hotel in Pasadena, where, of course, he was staying, in a one-day session in probably April of 81. And then we were given, I think, 5 or 6 weeks to write and exchange trial briefs. And I'm going to show this because this is my magnum opus. It's not all mine, but most of it is. 268 pages plus another 100 or so of appendices. This was our post-trial opening brief in the case, and this was our reply brief, to which I have to say our opening brief, I think the tribes knew that they had a leg up going in with the judge because they dismissed our arguments in a brief that was about a third the size, which was rather annoying. But anyway.
Just for the record, the
Yes.
name of the case.
Name of the case, State of Arizona, complainant versus State of California, Palo Verde Irrigation District, Imperial Irrigation District, Coachella Valley County Water District, the Metropolitan Water District of Southern California, the City of Los Angeles, the City of San Diego, and the County of San Diego defendants. United States of America and State of Arizona interveners. Now, why Arizona was well, they were the complainant. I don't remember why that is. And then State of New Mexico and state of Utah impleaded defendants, but they didn't really participate. Nor did Palo Verde and Imperial after a certain point. They basically decided that they had their present perfected rights. They had early contract rights. They didn't really have much at stake in, they weren't suffering much from the tribes getting more water rights along the river. And Coachella, because their rights were a little more uncertain in terms of the quantity, and also they had a relationship with Met's rights, which I won't get into because I'm a little hazy on it. But Coachella stayed in, and of course Met stayed in. And San Diego and LA stayed in because, of course, they took through Met and they were interested, although they played a pretty minor role. It was basically, do you want me to talk about the principles in the case?
That would probably be a good idea.
And then we can get to the legal issues. Yeah. The two lead trial attorneys on our side were Carl Bronke, who at that time was chief counsel at Metropolitan Water District, and Ralph Hunsaker, who was with a private firm in Arizona, but they represented the Arizona Department of Water Resources. So Ralph and Carl were the main trial attorneys. There were two more of us, at least early on. There was a junior attorney at Metropolitan Water District. I don't know that I need to mention his name because there were some real problems with him in the case, and he was removed, and he held it against Carl and me, and anyway, he was removed from the case. And the other, I'm sorry, where was I here?
We're going over the participating attorneys in the case.
Right. And the other main attorney was I, except I wasn't really the litigator. I was assigned, I think, pretty early to be the note taker and be largely responsible for the trial brief. So Ralph and Carl, we actually, well, here, let me go back. The U.S. and the tribes had made the motion. We had made the motion to enter the PPR decree, but that was done. The U.S. and the tribes were the moving parties on getting more rights for the tribes. So I think they basically submitted their claims, and then we answered them. The U.S. hired a firm called HKM in Helena or Billings, Montana, a guy named Al Kursich, who was their lead partner. And they made certain additional claims. They also had an economist named Alan Kleinman. They had some soil analysis place in Albuquerque that did a soils report. I forget what they're called, not the Soil Conservation Service. That's definitely not what they were called. I forget, anyway. But Al Kursich was their main expert. And their attorney was a guy named Miles Flint, who was head of the division that dealt with this at Justice. These were Justice Department attorneys. And his young deputy, Scott McElroy, who has subsequently become counsel for a number of the tribes, but he was U.S. counsel, fairly young guy, younger than I was at the time, and he was the main trial attorney for the U.S. in the case. The U.S., let's see, how am I doing this here? Let me go back later to the difference between omitted and boundary lands, and then the nature of the claims, and how the U.S. made different claims than the tribes did. But for the moment, let me just talk about personalities. The tribes were represented, let's see, a guy named John Mullins from a firm in Denver, a private firm, represented the Colorado River Indian tribe. That's by far the tribe with the most water rights, although most of them are in Arizona. And I think early on, though I'm getting a little confused here, the Fort Mojave tribe, I think was represented by a guy named Dan Israel, who's also, I think he's from Boulder, Colorado. The Chemehuevis and the Cocopas kind of, they weren't really participating much. And they had some claims, but I think those got resolved or something. I'm a little mixed up there. But the Fort Yuma tribe, the Quechans, they were always marching to their own drummer. And they initially had Ray Simpson as their attorney. Ray was an old-time trial attorney. He had this massive shock of white hair. He looked like, I don't know if he looked like a stereotypical old-time attorney or a caricature, but he was very glib, and sometimes we felt a little lacking in substance. I remember when we flew to Atlanta for one of the hearings, you know, there were all of us riding coach, and suddenly this man comes back from first class, and it's Ray Simpson. And he's suddenly very chagrined that we've seen him come from first class, since he's representing this impoverished Indian tribe and undoubtedly flying on their money. And he said, now I hope you understand that, you know, and he was trying to polish us over, and we just kind of laughed. He was actually supplanted in the case, I think by his choice, quite early by a guy named Bob Kirkpatrick or Kilpatrick from Long Beach, who was much more of a trial attorney and was really a pretty effective guy and a little bit of a pit bull in a way, but he was the and of course the Fort Yuma as well. We can get into that later, but they took a different tack from everyone else. They had reports that frankly didn't have much substance to them, to say the least. Anyway, on our side, we hired, or the state, actually I think it was the 6th Agency Committee, now that I think about it, hired Bookman Edmonston engineers as our expert. And this was a little odd, and I guess I should be candid here. I mean, the state for years, the state of California had had Tom Stetson under a retainer contract, and he did various things for us, and he probably would have participated in this case, but apparently he'd worked at the Colorado River Board when Myron was first there, and Myron didn't get along with him. And anyway, to be quite candid, before I even knew it, the 6th Agency Committee, and I think Myron had, you know, obviously talked to them, had hired Bookman Edmonston engineers, and they became our experts, and they were fine. And Tom Stetson, who was under contract to the state, he had some minor role, but Bookman Edmonston was the main series of experts for our side. They had 4 people that they had. One of them was a guy named John Bailey, who was an old salt guy. He was a man probably pushing 70 at the time. He was a soils man, and he analyzed the soils and was as honest as the day is long. And unfortunately, he was assigned to work with this young attorney from Met, who subsequently Carl removed from the case because there were a lot of problems with him. And poor John Bailey, Ralph Hunsaker ended up taking over John's testimony. Let's see, I'm Dave Powell. Who am I forgetting here? Oh, of course, Maurice Langley was an old-time Bureau of Reclamation guy from Washington, D.C., who had developed a system of measuring water holding capacity of soils. And he had very strong and well-developed opinions about the inability to grow anything on sandy soils, basically, and had strong views about gravelly, cobbly soils, which most of these soils were. I mean, most of the land that was claimed for additional water rights was either land that hadn't been so obviously irrigable in the first place that the U.S. claimed it back in the original case, or lands that had to do with boundary disputes, which we can talk about in a minute. But they tended to be marginal lands. They were lands that were either really bad and not irrigable in our view, or lands that were a little marginal in terms of their content of soils, how high they were above the river, which had to do with pumping costs, what could be grown there, whatever. Anyway,
just for clarity,
yes,
talking about the issue of
practicably irrigable acreage,
and that had to do
the measure of the Indian water right under the as held by the Supreme Court in the original case of Arizona, California, and this was the first time the term had been used. The measure of the Indian water right was to be how much water was needed to irrigate all the practicably irrigable acreage within the reservation. And and as it came to be understood, practicably irrigable acreage meant that you could farm it economically. Practicably irrigable was a little different from arable. Arable was basically, could it hold enough water and was the soil good enough to grow a crop? Practicably irrigable meant, could you grow the crop but also sell it and market it profitably?
Okay, the important point, or one of the important points here, is that in a fashion very much like the this year's quantification settlement agreement settled for at least two of the agencies, the argument was not over a finite stated amount of water, but rather the amount of water that would be necessary to irrigate practically irrigable acreage. There, I just want to make sure that that's correct and that people understand.
Well, yeah, but in the we were pretty much, when we entered the decree in 1979, the supplemental decree on present perfected rights, we had incorporated within that decree the subordination agreement, which allowed the Indian rights to be satisfied ahead of the major PPRs, major state PPRs. But we'd also included in that any additional rights that the tribes would get through this, through their claims.
Okay.
That had, and we'd assigned a water duty for each reservation based on some figures from the original case. In other words, like on Fort Yuma, any additional acreage was to be, per acre was to be given 6.67 acre feet of diversion right. I think it was something like that. And it varied from each reservation. So the amount of water, the diversion right of water you were to get on each reservation was already fixed in the supplemental decree of 1979. All we had to determine was how many practicably irrigable acres there were. Okay?
Okay, so the amount of water per acre was determined.
Right, right. We had to figure out how many acres.
If the tribe said there were 100 irrigable acres and the state said there were 10 irrigable acres, that's a difference of 90 irrigable
And that's
acres.
what the judge had to resolve.
And so you're disputing 90 acres times
Right.
6.
And that's what and we had a battle of agricultural economists, soils people, yields people, power, pumping costs. You know, we had the battle of experts to determine that. And what I'm telling you now is the 4 experts on our side: John Bailey, who was hired by Bookman Evanston, I guess he worked for them. He was a soils person. Maurice Langley had this view on water holding capacity of sandy soils, and pretty strong views. And he'd invented or I guess he'd sort of developed this system. And to some degree, in my view, he was so tied into his own system and it was based a lot on flood irrigation, based a lot on the ability of soils to hold water under flood irrigation conditions, less so under sprinkler or drip. And so when we were faced in the case with claims based more on sprinkler and drip, I'm sure in his view, maybe his system answered everything. And I can't go back now and give you a detailed analysis of why I think some of us had doubts about that, but I think in a sense, we got too tied into his view of water holding capacity. But
okay, let me stop you on that point.
Then we had 2 more experts, which we'll get to.
Okay, and we're stopping tape 2. Doug, where we stopped the last tape, we were talking about some of the experts that had been hired on the omitted lands and boundary
lands, right.
lands case. And why don't we pick it up at that point where you were talking about the expert witness.
Right. Well, the 3rd expert was a guy named Bob Beebe, who I was actually assigned to question. This is one of my few litigation assignments in the case. Although I will say I did get to cross-examine the chief partner from Boyle Engineers they were the experts for the tribes who were making all these ridiculous claims about permanent crops. But I did get to cross-examine him on some point about calculating interest that he had totally missed, and I think I hung him out, frankly. But that was one of my few triumphs. But I was assigned to to take Bob Beebe as one of the 4 experts, and he was just a wonderful witness. He was a junior partner at Bookman Edmiston, but he testified in agricultural economics and tried to pull together some of the testimony of the soils people. And then the 4th expert was the senior partner or a senior partner at Bookman Edmiston, Dave Powell, who Carl Bronche took, and Dave was supposed to give sort of the overview, and he did that. And Carl took him. So those are the 4 experts. Let's see. Let me go next to the nature of the issues here and what was involved. And I don't know how much, well, some of this, as I say, is on the other tapes I've done, but let me do it briefly. There were 2 types of claims here. One was for what were called omitted lands. These were lands that the tribes in the U.S. claimed were practically irrigable, but somehow, and were known and considered and accepted to be part of the Indian reservations during the time of the original lawsuit.
Let me put you on
Yes.
pause here for just 1 second, because it just occurred to me that the microphone is sitting on the table. And I think we're okay. I think we picked it all up, but let's put that back where it goes. That's my fault. I didn't see.
Do you want to check it?
No, that's fine.
Okay.
You've got a good, strong voice.
Anyway, the omitted lands were claims for lands that were part of the Indian reservation, could have been asserted as practicably irrigable for water rights in the original lawsuit, but for whatever reason were not. Now, the tribe's position was that they were not asserted as irrigable because the U.S. was basically incompetent. The U.S. didn't really give any reason why they didn't assert them, but that didn't seem to block them from asserting them now. We took the position from the beginning that could not be done, that was basically res judicata. It had been determined. The issue could have been before the court before. Any lands within the original boundaries of the reservation that were irrigable should have been asserted as such at the original trial, and that once they weren't, they were done. Special Master Tuttle dismissed that argument basically out of hand, went ahead and conducted a trial on the practicable irrigability of those lands. It was only later when we filed exceptions to his report to the Supreme Court, and I think we should say that when a special master takes a case and acts as the trial judge, he makes a report to the Supreme Court because he's acting as their agent, really. And then it's up to the court itself to decide whether to accept the report. And parties that don't like the master's recommendation can file what are called exceptions. We filed a number of exceptions, including on his ruling about omitted lands. And the court itself, when Carl Bronche argued the case in 1982, upheld our position. They threw out all the claims for omitted lands, saying those should have been made before at the earlier trial, and when they weren't, you're barred from making them now. Nevertheless, we had gone ahead and conducted a trial on the practicable irrigability of all of those lands for nothing, but we won on the final analysis. The other claims were for what were called boundary lands. These were lands that were not recognized as being part of the Indian reservations at the time of the original trial, but 2 of which at least, on Fort Mojave in Colorado, had had disputes over the boundary of the reservation, which were in existence at the time of the original trial, and which had come before the court. In other words, the U.S. representing as trustee the Colorado River Reservation and the Fort Mojave Reservation had asserted before Special Master Rifkin at the original trial that the reservations were, that certain boundary disputes should be resolved in favor of the Indian reservations, which would have enlarged the reservations and given them the basis for claiming more practicably irrigable land. The Special Master Rifkin had actually ruled in the state's favor on both of those boundary disputes, saying that the reservations weren't larger, but because there were a lot of other potential non-Indian parties involved, and there were other parties that had some potential stake in those determinations, and who hadn't been joined as parties, and I think that was the main reason. The state of California actually raised the point that they didn't think maybe it was appropriate to try and make that recommendation. And so those issues were never resolved at the original trial, and the boundary disputes remained in dispute. There was a third boundary dispute. The Fort Yuma everyone thought had been resolved back in 1936 by a solicitor's opinion by Solicitor Margold at the Department of Interior, but the issue got raised again in the early 70s. And I know you had an earlier question about this. Did we have a say in this? In the early, and I'll go back to that. In the early 70s, the U.S., and I'm a little mixed up now. There was I don't know where it came from. I think it came from the Fort Yuma tribe, but then it was picked up by the Bureau of Indian Affairs. Anyway, it was during the Reagan, no, wait a minute. Let's go back here. It was during the Ford administration, Ford or Nixon administration, that the Department of Interior basically opened up the issue of this Fort Yuma dispute. Now, I don't think you want me to go into what that involved, do you?
Probably not.
Yeah, okay, because I think probably other people have discussed it. Yeah. Anyway, it was reopened, and it was Secretary Kleppe, I think, Thomas Kleppe, who had been governor of North Dakota, who was Secretary of the Interior. Pretty sure the meeting with him, where we all went back, and Carl, who was still in our office, Carl Bronke, and I went back for that meeting. I'm pretty sure, I know we went back for some meeting, and we went back several times, but I'm pretty sure we went back there and presented our arguments as to why the Fort Yuma claim was not a valid claim, and the U.S. on the Fort Yuma's behalf. Emil Stepanovich and I, who, as I told you earlier, was my backup on the Colorado River Board, wrote a long paper on that, taking one position, arguing against the Fort Yuma claim. Jerry Mize, who hadn't at that time been really involved in the case for some time, although he'd been in it in the 50s and 60s, he wrote an additional paper, which probably was a little bit better reasoned legally and had some other points in it, that sort of became the state's position on the Fort Yuma dispute. And basically, before the Ford administration ended, an opinion was written, I think it was by Solicitor Greg Austin, that upheld the former opinion, the Margold opinion, if I'm not mistaken. I'm getting this a little confused. Anyway, by the time the Ford administration ended, the matter was still basically resting on the earlier solicitor's opinion that the Fort Yuma claim for additional lands, boundary lands, was not valid. When the Carter administration came in, he appointed a guy named Leo Krulitz as secretary, as a solicitor at the Department of Interior, and it became apparent that there was going to be a move by Interior under the new administration to overturn the Margold opinion from 1936 and recognize the Fort Yuma claim. We asked that we be given our day in court to be heard before any such decision was made. We were not. We were told, I think, that we would be, and we never were. And when the tribes and the U.S. filed their motion to reopen the case, which was, in response to our motion on the Present Perfected Rights Decree, when they filed that motion on December 20th, 1978, the day before that, December 19th, 1978, Solicitor Krulitz had issued an opinion overturning the Margold opinion, recognizing the Fort Yuma claim, and the Secretary of the Interior, I think, had signed off on it, giving it some semblance of validity. We were outraged. I mean, I don't think there's any other way to describe it, because we were totally given no day in court. Not only that, but as to the other two boundary disputes, I think there were secretarial orders issued on those two, one in the Fort Mojave and the Colorado River, one solicitor's opinion adopted by the Secretary of the Interior in an order, one in 69 and one in 74. And in none of those two or the Krulitz opinion, did the state parties really have their day in court. So the U.S. and the tribes were coming in based on orders by the Secretary of the Interior resolving longstanding boundary disputes, and on the basis of those orders was making a claim for additional present perfected rights. We said before Special Master Tuttle that we hadn't had our day in court, that we were entitled to litigate the validity of those secretarial orders recognizing the Indian position on the boundaries. Special Master Tuttle denied us that opportunity and said that I think he basically said that if additional water rights were assigned for those boundary lands, that at that time we'd have an opportunity before those were finally decreed by the court to raise the issue or something like that. I'm trying to remember. Our position was, if we're right on the boundaries, if you can make a decision on the boundaries now and the decision is in our favor, we won't even have to litigate the question of how many practically irrigable acres there are within those boundary lands. Similarly, for the omitted lands, we said if you throw these out now on the grounds that all those claims should have been made earlier, then we won't even have to have this long trial on practically irrigable acreage. He refused to do either, so we had the trial. As it turns out, when we went back to the Supreme Court on our exceptions, as I said earlier, the court threw out the omitted lands claims completely, gone, done. As to the boundary lands, they said, well, these boundaries have not been, quote, finally determined because the other parties with an interest weren't given their day in court.
Now, these were boundaries of the Indian reservation.
Boundaries of the Indian reservations, that's right. While this was all pending, and let me go back to the practically irrigable acreage issues in a minute, but while at some point, before, let's see, okay. Special Master Tuttle basically forced us to have a full trial on the practically irrigable acreage for both the omitted and boundary lands, okay? And while that trial is proceeding, and then it ended, at some point in there, and before we went up to the Supreme Court with our exceptions about boundary and omitted lands, Metropolitan Water District decided that the best strategy was to file an action in federal district court challenging each of the secretarial orders on the boundary disputes, even as we were litigating the practically irrigable acreage within those acreages before the special master. And I don't remember the exact timing, but I know it was before we went up to the court with our exceptions. So they filed in San Diego. We were assigned to Judge Rudy Brewster, U.S. District Court judge there. Met was the main party, and I think Coachella was in it, and the state joined. So we had a trial, and they decided to try one boundary dispute at a time. So we did the Fort Mojave one first. And it was a fairly 2 or 3 day trial, just arguing legal points. And then the judge took it under submission for over a year. I mean, it was incredible how long it took. And he finally made a decision in favor of the state parties against the claim of the U.S. and the tribes. Meantime, and this is where I'm getting a little hazy, and I'm sure Carl remembers this better. Meantime, when we made our exceptions to the Supreme Court, we went up to the Supreme Court challenging the judge's hearing the case at all, because he shouldn't have heard it because the omitted boundary land shouldn't have been before him, and challenging the number of practically irrigable acreage he found. We pointed out that we'd filed this other case. Carl Bronke was arguing, and he pointed out that Met had already filed this case trying to get our day in court on the boundary lands in district court. And in that case, the U.S. down at the district court level had asserted sovereign immunity as a defense to being sued by a state over these boundary determinations. And I won't get into that. But before the Supreme Court, Louis Claiborne from the Solicitor's Office, arguing for the U.S., said he basically disavowed that defense. He disavowed before the U.S. Supreme Court, representing the U.S., the defenses asserted by Department of Justice attorneys in the district court case. We figured that would probably put an end to that defense in the district court, but it didn't. And what happened was the government went right ahead and asserted the defense. And when they appealed Judge Brewster's ruling on the Fort Mojave tribe, they asserted sovereign immunity, and the Ninth Circuit bought it. They overturned Judge Brewster's opinion. And that case eventually went up to the U.S. Supreme Court, Jerry Mize arguing it, and the court split 4-4. Thurgood Marshall recused himself because he'd been in the administration as Solicitor General during the original lawsuit. So he recused himself. It was 4-4, and on 4-4, the lower court decision stands. So our case, in which we had won on the Fort Mojave boundary dispute, was thrown out. The dispute was still pending, and the other two disputes had never even been reached, the Fort Yuma and the Colorado. And so when that happened, we petitioned the Supreme Court again and said, you know, you should have resolved this. You should have sent this out for trial. The court had refused, well, I'm getting very muddled here, but hopefully it will all sort out later. Basically, at that point, we said, because by now the Supreme Court had decided that we were entitled to our day in court on the boundary disputes, but that they weren't the court to conduct that hearing, because let me try to explain this so it's clear. Let's leave aside the practically irrigable acreage claims for the moment. Let's just leave those aside. We'll go back to them. As you recall, Judge Tuttle said, I don't care if they're boundary disputes and you claim you haven't had your day in court, but if I assign water rights based on these enlarged boundaries, then at that time you can challenge the boundaries. And we said that's ridiculous, but that was what we were stuck with. So when we took his ruling up to the Supreme Court, we said, you know, he never should have even conducted the trial on practically irrigable acreage because these boundaries haven't finally been determined, and we'd like the court to appoint, or they need to be finally determined. And the court said, well, you've already filed this case in federal district court. So even though we don't think the boundaries have been finally determined, it looks like they're going to be determined there. So we'll let them do it. Then, of course, that case got thrown out on sovereign immunity. So we go back to the Supreme Court and say, look, we can't get them determined because the U.S. has asserted this defense. So Supreme Court, you got to take this up. And at that point, all the parties agreed the first time, and they appointed a special master, a guy named McKay, who was a professor at New York University Law School, to be the special master to determine the Fort Mojave, the Colorado River, and the Fort Yuma boundary disputes. Special Master McKay died on the eve of one of our hearings, and they appointed Frank McGarr, who was a federal court judge in Chicago, to handle the case, and he's been the special master ever since. And our first meeting with him was on his 70th birthday, and that was 12 or 13 years ago, and the case is still going, and he's still alive and in Chicago. So that's why the Fort Yuma dispute, the other two disputes have settled. The Colorado and the Fort Mojave have settled. The Fort Yuma dispute is still before it. Now, I've jumped way ahead. I understand that. Let me go back. Shall I go back to the third issue before Tuttle? Judge Tuttle said, I'm going to consider, he rejected the state's arguments on the omitted lands and boundary lands and said, we're going to have a trial on the practically irrigable acreage claims for all those lands. And we did, 8 weeks. Now, here's the deal. The U.S. and the tribes both represented the tribes. The tribes had two sets of counsel. The U.S., as I said, Miles Flint, Scott McElroy. The tribes, each tribe was different, but they combined. The Fort Mojave and the Colorado River tribes both hired Boyle engineers in Irvine. Now, as I told you, the U.S. had hired Al Kersich, HKM Associates in Helena or Billings, Montana. And they had, in their claims, had made relatively within the ballpark claims based on crops that had traditionally been grown in the Colorado River Valley. Cotton, alfalfa, wheat, lemons. those crops that had a history of growth there. So we could at least accept that fundamental premise. Our argument with them was, how bad are these soils? What's the water holding capacity? What will the nature of sandy or gravelly, cobbly soils do to yields? How expensive will it be to get power up to some of the lands that are above the grade of the river?
You mean to pump water up?
To pump water. The claim was made by the U.S. that the tribes are entitled to under the Levitt Act, or entitled to some beneficial power rate, especially subsidized rate or something. And we said that should be irrelevant to this because that's a special benefit of the tribe, but that doesn't go to whether the land itself can be irrigated economically, because somebody is absorbing that cost. We didn't get too far with that argument. Anyway, the point was that we argued against them face to face. I mean, those were based on crops that we could get a handle on, that we felt were at least appropriate to being grown there, even if we thought the soils were inappropriate. So we accepted some of the claims by the U.S. on behalf of the tribes that those lands were practicably irrigable. We agreed with some of them, and we disagreed with others. And we litigated the ones we disagreed with. We at some point reached an agreement on the Colorado River claims on the Colorado River Reservation I think we reached an agreement as to how many of those were practicably irrigable, and then we went ahead and litigated the others. But I'm getting a little mixed up there. Anyway, that was the thing that was our dispute with the U.S. The tribal experts, Boyle engineers, they projected far more lands as being practicably irrigable than the U.S. did. But in order to do that, these were lousy lands. They were way up, they were real gravelly, they were crummy lands, which is why the U.S. couldn't project them as profitably being able to grow an alfalfa or cotton or whatever. What the tribes did, Boyle engineers did, was project high revenue, what we called exotic crops on those lands that would bring in, if you could produce them, enough revenue to offset the increased costs attendant to the fact that these were crappy lands. And what they did was they projected pistachios, almonds, figs, and table grapes as growing there. Well, there was no history, no commercial history of any of those crops except maybe table grapes growing in the area. So we said it's inappropriate. One, it's inappropriate up front to even project them. Inappropriate agricultural economics, it just shouldn't be considered at all. But then, of course, we knew that Judge Tuttle was going to consider them. So we had to go through each one and analyze point by point. And for each one, and that's what takes up a lot of room in this brief, like for pistachios, to grow pistachios at all, I'm just doing this as an example, you have to have a certain number of what's called chilling hours. The temperature has to be below a certain temperature and stay within some range, and it has to be below that temperature for a certain number of hours for the plant to properly mature. They cited evidence. There are a lot of pistachios grown in the San Joaquin Valley, as you know, I think. And they took figures from there and projected them to the Colorado River Valley. The only problem was in the Colorado River Valley, while the temperature may get down as low as it does in the San Joaquin Valley, it also gets up above a certain point. And it was our position, based on our economists' view and analysis and study, that you have to offset the number of chilling hours below 45 degrees by the number, I think, above 70 degrees, and you get a lower number. And they hadn't done that. And in the San Joaquin Valley, in the winter, you don't have those temperatures above 70 or whatever it was, whereas you do in the Colorado. So that's just one example. We did, all kinds of things. How difficult is it? Almonds are harvested off the ground. How difficult is it to harvest almonds when you've got gravel and pebbles all around? Grapes get an ambering effect if it's too hot in the sun. I mean, all kinds of issues as to each crop. We raised those, but we had to go to the mat on everything. And the judge, I will say to his credit, he didn't rule in their favor on everything. He actually, on the Fort Yuma Reservation, most of their claim is for this alluvial plain that slopes up from the All-America Canal, and most of it's called the Araz Wash, and it's gullied and rutted, and it's got rocks and everything on it, and he threw out a lot of that, but he also gave them a lot of it. He didn't accept figs or pistachios. We convinced him on that somehow, but he accepted almonds and table grapes. But almonds, now, let's see, almonds and table grapes, though, were projected for the Colorado and Fort Mojave reservations. As I said, we settled on Colorado early on, so I think that was out of the park, or maybe that was just as to the U.S. claims. That's right. We settled as to the U.S. claims there. We didn't settle as to the Boyle Engineers Indian claims. So he basically found almonds and table grapes on both those northern reservations, but there wasn't actually that much land involved there. There was a lot of land, though, on the Fort Yuma reservation. Now, as I think I said earlier, the Fort Yuma's with this guy Ray Simpson, with his lock of white hair, his mane, flying first-class air at the expense of, presumably, this impoverished Indian tribe. They always had to do their own thing, and they hired a separate soils guy and a separate economist, Lord and King. And I have to say, in all honesty, that there was very little substance in their reports. They tacked on to Boyle Engineers on some of their figures, but they were throwing all kinds of things out there. They were talking about growing jojoba beans as a crop. I mean, they just talked about it. They didn't give any figures. They only projected, of the Boyle crops, though, they only projected table grapes as viable. And that was what Judge Tuttle found. And he gave them the equivalent of, God, it was like 50,000 acre-feet based on table grapes. We had an expert, one of our attorneys, one of the Coachella attorneys, was convinced that he had an expert that could blow out the Yuma claim on table grapes. The only trouble is, and I won't mention the attorney or the expert because I really felt strongly about what a bad miscalculation this was, but the expert turned out to be a grape grower in the Coachella Valley who obviously had a complete vested interest in not having more grapes grown down in the Colorado that would compete with him, because they both came onto the market at the same time, as I recall. So that expert he cost us, if anything. What I think should have carried the piece was that in order to make the Araz Wash lands, and this actually, if this case ever goes to trial, because this is the dispute that's still out there, if this case is ever relitigated as to practically irrigable acreage, and I think it will be, because the figures, if it ever needs to be, if the Yumas win on their boundary dispute, if it's ever relitigated as to practically irrigable acreage, maybe this will no longer be an issue. But as of 1980, in order to make this land appear practically irrigable, in other words, economic to farm, they had to project such a high price for their grapes that they projected an unrealistic grape price. It was based on a spot market in Phoenix, Arizona. But the spot market in Phoenix, which would have come in at the same time as the grapes down at Fort Yuma, was for a very small quantity of grapes. So in other words, if the number of acres that Judge Tuttle gave the tribe, the Fort Yumas, for grapes, produced grapes that came in at the same time, it would have destroyed the price in that spot market, because it would have flooded it with more supply and brought the price down. So it was totally absurd to project that spot market price, and without that, it wasn't practically irrigable. We made that point. Judge basically said, too bad, it's a good price, I'll take it, or something. So that was it. So it was a fascinating case. As I said, Carl Bronke and Ralph Hunsaker were the two main trial attorneys. I took one of the four experts, but they did most of the cross-examining of the other side's experts. They did most of the litigation, and I was the note taker. They could see early on that I liked taking notes. I guess they were happy to have me do that. ended up putting in the most time I've ever put in on any case. I averaged 100 hours a week for 3 weeks and was working till like 3 in the morning doing this brief every day because we had very little time and there was a lot to put in. We had a 7,200-page transcript, which luckily I had taken enough notes on that I didn't have to read the whole transcript. I could reference from my notes as to where we were in the transcript and find the information I needed because I had pretty good notes. So with a lot of input from Carl and also Jerry Mize, who was talking from DC, we produced this brief, and we also had an appendix for each claim was based on a particular parcel of land. The U.S. claim as well as the tribal claims, they had separated their claims into particular parcels. So we analyzed each parcel. We had an appendix for each parcel of land. And we had our general objections to their claims, as I've outlined before, and we submitted it. They replied with very short shrift. They kind of knew, I think they had the judge wired, and they really didn't address a lot of our points, frankly, or they dismissed them with pretty, they probably could have made a better case had they thought they needed to. Because, our side, we had compelling arguments, I thought, but, they weren't open and shut. They basically stiffed us, I thought, on their briefs, and then, of course, we had to file a reply. The judge came down with his decision sometime later. As I said before, he recognized most of the disputed claims that the U.S. had made. He gave us a few. But as to the tribal claims, he threw out figs and pistachios, but gave them almonds and table grapes. He threw out some of the lands, but he gave them about 70, what was it? I'm forgetting now, but upwards of 100,000 additional acre feet. We of course filed exceptions both on the omitted and boundary lands. We won on those. We filed exceptions on the practically irrigable acreage claims, but because the court threw out all the omitted lands and said the boundary lands hadn't been finally determined, the Supreme Court, on our exceptions, never got to our exceptions on practicably irrigable acreage determination. So as far as technically speaking, those exceptions are still pending. If we ever went back to the court, and let's say on the one remaining case, the Fort Yuma case, and we lost on the boundaries, and the court upheld the enlarged boundaries for the Fort Yumas, then technically our exceptions to the practicably irrigable acreage determination for those boundary lands made by Judge Tuttle 23 years ago would still be before the court. But the parties now have agreed that we have to have a new trial on practicably irrigable acreage, and I think they're going to conduct it, unless the case settles, at the same time that they have the argument over the boundary dispute itself. Because one thing is clear, the Supreme Court does not want to have this piecemeal. They want to have it one more time. They've made that clear. So even though we might be wasting our time on I'm not there anymore, it looks like there is going to be a new trial on practicably irrigable acreage and on the boundary dispute for the Fort Yuma Reservation, assuming it doesn't settle. And that case has now been turned over to my successor, Bill Abbey, in the AG's office, and Linus Massaretis is the lead attorney along with Jerry Mize for Met, and there you are.
Okay. Doug, you were involved, I think, at the very tail end of the what's known as the Laughlin River Tours case. It was an important case at the time because it involved tourism in Laughlin, Arizona, which of course has exploded here in the last
Laughlin, Nevada.
Laughlin, Nevada. Thank you. You tell us about picking up the pieces at the end of that case.
Well, the basic issue, as I recall, was whether a certain minimal level of water needed to be maintained in Lake Lake Mojave to support these like stern-wheeler river boats that were operating there, and the Laughlin people were asserting that that where the I guess it's, let's see, is it Arizona? The Boulder Canyon Project Act talks about maintaining the river for navigation, irrigation, various things, that navigation somehow should have an equal role, or at least an equal role to other uses of the river, and that therefore to make it navigable you had to keep the water higher. And that of course meant wasting a lot of water and not controlling the river in a way that would maximize the use of the water by the downstream users. I mean, that was it basically, and very, very poorly stated. And I just simply went for the final argument of Pam Civitan, now Pam Collins, who was in our office that handled the case. She later went over and served on the staff at Met before she moved to Montana. And she basically left right before the case was having its final argument. So I did very little on the case except go over to Las Vegas for the final argument in district court, and made the base. I don't remember exactly what my arguments were, but it was certainly to the point that the navigation element shouldn't take precedence over everything else, and that there was balancing to do, as I recall, and the secretary had to make decisions like that. I don't remember. All I know is that we won, that and basically the regimen of the river was preserved. I mean, it would have been quite a threat if all this water, if this additional water had been required to be released from, I guess it's Davis Dam, or is Davis below? God, anyway, you would have had to release additional water above the demands in order to keep the river high enough to float these boats, and that water simply would have been lost, because it would have been more water than the downstream users could take at that time of year. I mean, it was something to keep the level up, I think, all year round, which isn't the way it works.
Right.
Yeah.
This is 2003. I don't want to get into every piece of water litigation that's going on right now. We'd be here for days. But with the quantification settlement agreement has just been signed within the last month of this interview. Arizona v. California, of course, continues. Other water litigation continues. Without regard to any specific piece of litigation or legislation, for that matter, what do you see in the water future? I didn't mean to give a speech with this question, but one of the headlines with respect to the quantification settlement agreement was peace on the river. And of course, there are a lot of people who think, well, maybe, or not. So with regard to the law of the river and what's going on today, where do you see the Colorado River and its resources headed?
Well, I'm not sure I'm the person to answer that, but I guess I was pretty amazed when the QSA was finally signed. It seems like we've had so many false starts and prospects of being signed, and then something happens at the last minute. And of course, in the final analysis, I guess the vote at Imperial was still only 3-2 in favor of signing it, which is, they've lost a few of those 3-2 votes in the past that have undone quite a bit. I guess the simple fact is that there's more demand for the river water than there is supply. We've passed the era of big dams. We've passed any notion of taking water from the Pacific Northwest. We've gotten to the point where Nevada and Arizona use their full share of the river, and for California to continue to use up more than 800,000 feet more than its basic apportionment each year simply couldn't be continued unless there's some permanent condition of surplus, which there isn't going to be. And right now, I guess we're in a bit of a drought condition, so that's exacerbated the problem even more. And obviously there's a lot of things that can be done, but you're dealing ultimately, and I try to be objective about this. I mean, I think there's just a long-standing, almost institutional conflict between city and farm here. I mean, Imperial, which has 3/4 basically of the California share of the first 7.5 million acre feet, they, in the view of many people for years, have been wasting water because they've had unlined canals. That wasted water, though, or the drainage water, has been what's kept the Salton Sea alive. And of course, some people think the Salton Sea should be allowed to die. But on the theory that it's going to be kept alive, the only solution to saving it is to somehow keep more water or enough water flowing into it. And how's that going to be done if you line Imperial's canals to make them more efficient and allow them to take less water from the Colorado, freeing more for MWD? I mean, I'm stating some pretty basic issues that have gone on here. But also, I think there's this underlying suspicion that's always been there by people at Imperial that Met and the big city is going to come in and take their water eventually. And of course, there's the feeling from the other side that Imperial is wasting water, and and of course, you know, as with any retirement of agricultural land, you free up so much water by retiring even a small portion of agricultural land for municipal industrial use. So there's just been this conflict there forever. I doubt that this solves it. I'm sure there will be issues that come up in the future, but at least it appears, and I've been gone for 3 years, although I read the paper and I occasionally go to Colorado River Board meetings, but I assume that this means that at least there's a reasonable chance now of getting the acquiescence of the other states to having surplus declarations made by the Secretary during the period that the California is ratcheting down from 5.2 to its 4.4 million acre feet. And of course, I think probably what prompted the final QSA agreement was the fact that this administration in Washington had actually cut Met off. It cut off California at its 4.4 when it couldn't get its act together earlier. I don't know, you know, I don't know what the future is, and I don't think I'm the right person to ask, because I'm a lawyer, not a water planner. I just it is kind of amazing to me that we've gotten this far. Although I think I would imagine, without knowing any more than I do, that pressure, that the actual cutback and the pressure from the federal government had a lot to do with finally shaping everyone up. But I'm not sure. I don't know enough about it to know who finally gave, or if both sides did. I assume both sides, or all sides, gave in the end somewhat. But what's always amazed me is what a conspiracy of politeness there is on the Colorado River Board. I mean, these people meet every month and they're very gentlemanly to each other, and here they're out, you know, they're fighting hammer and tongs and castigating each other in the press too. I mean, not necessarily the same individuals, but it's always kind of amazed me. There was sort of a sense of unreality at times on the board itself, because people were kind of sitting there politely working together while their agencies were fighting it out. I found it fascinating. I don't know, where was the question going here?
No, we're
Yeah.
good. We're good.
Yeah.
In the last few minutes here, we've talked quite a while here. You've mentioned a number of people. Carl Barranchi comes to mind, Myron Holdert, and I think we have a sense of what your thoughts are about them, unless you want to add anything. But one of the things that we have been asking people is just a quick impression of some of the interesting people that you ran across. Now, why would we want to know that? Just for your own thought process. And my purpose is in helping someone that is in fact doing some research 20, 30, 40 years from now. I think they're going to want to know who the other players were.
Mm-hmm.
Who were some of the other players?
Mm-hmm. Mm-hmm.
I don't know them all, so if someone comes to your mind that you think should be jotted down here in this particular oral history, so that someone in the future can look them up,
Right.
and say,
Right.
well, what did he or she have to do with it?
Right.
So what I'd like you to do, I'll just say a couple of names, and we'll see where that leads. But like I say, just a sentence or two about their significance, and if there was something special about their personality and whatnot, please toss that in. So let's start with Dennis Underwood.
Well, I can say this about Dennis. Jim Ryan, who was my backup on the Colorado River Board after Emil Stepanovich left the office, told me once he thought Dennis was the perfect client. The perfect client. He said and I agreed. I mean, Dennis was always on top of things, but he would keep you informed. He knew when to ask you to come in for your advice. He didn't do crazy things, and I'm not making invidious comparisons to anyone else by saying this. But Dennis was on top of things, but he also had a collegial relationship with you, and you always knew that you were sort of involved where you needed to be. And I think the world of Dennis, and obviously other people did too, because not too many people go from the executive director of the Colorado River Board to the commissioner of reclamation. And of course Dennis has, and now he's back at Met. But I like Dennis very much, and always found it very easy to work with him.
One of the names that keeps coming up in these oral histories, and I'm aware that you did not work directly with him, just because of the sequencing, is a fellow by the name of Mike Ely, an attorney by the name of Mike Ely. But you had to have run across him historically, if you will,
Yeah,
by writing or by reputation. I will tell you, if this prompts you, I will tell you that some of the people I have talked to thought he was just the greatest, and some of the people that I have talked to have suggested that he was just the worst.
Yes.
I haven't run across it was defined that way by so many different people. Having relied, I presume, to some extent on his writings or his legal work, any thoughts about Mike and his significance to the river?
Well, I think in his time he was really a giant in terms of his effect. Now, I mentioned earlier, and I believe I'm correct on this unless my memory has really deserted me, that in the acreage limitation case, our argument was that Imperial rightly relied on on a letter from the Interior Solicitor written in 1933, telling them basically that they weren't covered by the acreage limitation. And I think Mike Ely was the guy that wrote that letter. He was solicitor under Ray Lyman Wilbur, Secretary of the Interior, in 1933. When he was a young man, he would have been about 30 years old. He also, as you know, I think he was hired by the state of California as special counsel to represent them in the original trial, and it was he who associated with himself a very young Jerry Mize right out of Stanford Law School, and Jerry, of course, worked on the original trial out of Washington, D.C. Mike Ely, I know he was very controversial in our office. My impression of him was, from what I heard from other people, was that he was never had any doubts about the correctness of his position or his strategy, and that sometimes that was both a strength and a weakness. That I know after we lost Arizona, California, and we did lose it at the original trial, and he was, as I understand it, really the architect of our position a lot, although there was a guy in our office named Charlie Corker who was quite heavily involved too. And I don't know if this applied just to Charlie or to Mike, but there was some controversy in the AG's office after the case came down, because most of the people in the office had something to do with the case. It was a very small office then, it was a big case, and there was a guy in the office named Gil Nelson who apparently disliked Charlie Corker, and perhaps Mike Ely too, I don't know, quite intensely. And after the case came down and we lost, he circulated a memo around the office saying we would have done better had we defaulted. I always had the feeling that Mike Ely was, it seemed he was under, I think DWP kept him under contract for years, and of course the first 10 years or so I worked with the Colorado River Board, he was under $1,500 a month retainer to the 6 Agency Committee, and I know that Myron Holbert bristled at that thought, because he obviously didn't think very highly of Mike. I don't know. I met him maybe only once or twice, oddly enough. I had the feeling that he was perhaps a little out of touch with the reality of things, that he was so wedded to the positions that he took that he couldn't divorce himself from them. And I've seen that with other people. I think I saw it with Maurice Langley in our case that I talked about on water holding capacity. I think sometimes people get so stuck in the positions they have. You know, I found myself wondering the same thing. And I know I'm drifting here a little, but I have felt for years on the issue of whether or not Indian tribe reserved rights can be used or sold for use off the reservation. I felt that that is just a black and white, open and shut issue relating from the Winters Doctrine, which basically was a court-created doctrine to allow Indians to inhabit a particular area and make it profitable for themselves, and that therefore any water rights they had to pertain and be used on the very land that was in the reservation. And the thought of using it elsewhere just for profit just was totally contrary to Winters, which, as I said before, was a court-created sort of artificial right to begin with. But I see over the years, and this is where I say I may have been subject to the same thing, I see over the years there's such a movement away from that to give Indian reservations as much opportunity as they can to improve themselves, that whether or not legally, technically, wonderfully, in a pure sense, that was a correct legal doctrine, may not be in touch with the reality. And I think to some degree, maybe some of Mike Ely's stuff, when you look back, when I look now at the Boulder Canyon Project Act and the position that we took in the case, talking about how basically Arizona's use of the Gila River should be counted against its share of the Colorado. I know I've looked at that sometimes since, and I've thought, how could we make that argument? I mean, what were we doing there? And yet that was, that was a big thing in our argument. That was something that we were wedded to, and we went down in flames. And so I think, I'm sure Mike Ely was a great man and was obviously a giant in Western water, but I think maybe at least in the years when I knew anything about him, it seemed like perhaps he was fighting some battles that had already been lost. I don't know.
Anyone else come to mind that we've talked about a lot of people in the course of this?
Well, I mean,
anybody
I talked about Carl, who I think the world of, and he was my mentor in the Attorney General's office, and I was crushed when he left to go to Met. Met regularly. What's the word?
Rated.
What's the word? Picking.
Oh, cherry picked.
Cherry picked the best attorneys from our office. Warren Abbott, of course, went too. A number of other people went. I think the world of Carl, and as I say, he brought me into public resources in the AG's office, and then when he was at Met and lead counsel in the trial before Judge Tuttle, and I was lead counsel from the state, he acted as if I was still under his supervision, which in effect I was. But Bob Will, who I know very well and have known for years, I think a great deal of Bob. Bob, I don't think enjoyed litigating as much as lobbying, and that's where he ended up. And I guess he's about to retire from what I've heard. But Bob was an unforgettable character, and I know him and his family pretty well and have known them for years. In fact, I have a bookcase that Bob made that he generously gave me when he moved to Washington 20-some years ago. Jerry Mize, who's been special counsel to Met for probably the last 20 years or so. I'm not sure how big a role he's playing in the case now, because now that Linus has taken it over. But I think the world of Jerry. I know there were some issues with him and Greg Taylor at one time in Met over prosecuting the case, and I know Greg Taylor quite well from the AG's office, and Greg is a very unique personality, who I like very much, although I'm not sure I agreed with him in his little thing with Jerry Mize, but that's beside the point. I think Jerry did a really good job on the case over many years, and I've always enjoyed working with him. Worked with 4 different first chief engineers and then executive directors of the Colorado River Board. Myron, we've talked about. I like Myron very much, although, as I said, Myron has any doubt about the correctness of his position. I'm sure he would freely admit that and say, well, yes, I take that position because it's right. And, that's Myron. So, you argue at the periphery a little bit. Vern Valentine, who succeeded Myron, was there for a short time, and I worked with Vern quite a bit before he became executive director. When he was, I didn't work with him that much, but he was, Vern was there a short time, and then he went off on a mission, I think, for his church. Dennis, as I've said earlier, was just wonderful, excellent. guy and really wonderful. And Jerry Zimmerman, who I probably worked with longer than anyone else, I find to be a very sort of intriguing fellow. He doesn't come across as being very political, or sometimes doesn't really fully express himself, although I think he's changed a lot. But I think Jerry's very bright and really knows the river and the law and the issues as well as anyone I've worked with. But I found that working with him, I had to sort of draw him out, and he didn't always bring me in when perhaps he should have. I didn't feel aggrieved by this. I just felt that, you know, sometimes he got so busy with stuff that he was doing that that maybe by the time I heard about an issue, it was already well down the line. But and then when I'd go over and talk to him, it would you know, be kind of, sometimes it was kind of like, well, I won't say pulling teeth, but Jerry really knew the stuff. It was just a question of getting him to fully explain it. And but he's been there a long time, and I think he's done a real good job. I know there may be questions about his political. I don't know. And I probably shouldn't say anymore. I like Jerry very much. A lot of people I've worked with there who I enjoyed. Dick Angelos, who I worked with for years on the Lower Colorado River Supply Project. That was the project where by lining the All-American Canal.
Oh, wait a minute. Oh, I'm sorry. You're right.
By lining the All-American Canal and preventing leakage, which goes to Mexico, which has created an international incident. You are allowing Imperial to divert less water from the river, allowing more water to stay in the river, to create anywhere from I think it's 5,000 to 10,000 acre-foot supply of water for people that along the river, users who otherwise don't have rights. And Dick and I worked for some time trying to craft a sort of a procedure for the board to employ while shielding itself from litigation to do its part in administering that project. And I worked with him a lot. I worked with Ron Hightower for years before he left. Harold Pellegrin, who was the executive secretary, very, very nice man who I knew and worked with a long time. Ernie Weber, Ernie worked more on the salinity control stuff, and as I said, he worked with Emil Stepanovich, but I worked with Ernie a lot the last few years. And Fred Worthley, who I had known before. He was at Fish and Game and was our client, and I had some cases with him. And George Spencer more recently, who came over from DWP. And plus some of the other people, like some of the truly unforgettable characters like Merle Tostrud with all of his various toys that he had. We occasionally would share toys.